Mentioning জিজ্ঞেস করুন
My lordship, I kindly permitted to
from that side. Yes.
Mention one group 8 matters, appeal matters.
Hearing we are not taking up right now.
Lordship,
Too many
it
hearings.
is not a hearing matters, Lordship. It is to be mentioned, man.
Yes.
But to be mentioned for non-prosecution of a matrimonial.
Yes.
lordship, one first appeal and section 5 is the condemnation of delay.
Application, please mention, right? Application and mention. Right. Yes. Application, yes. Right, application and handover.
Hearing application.
Hearing we are not taking up right now. Too many hearings.
Application connection with matrimonial.
Please. Hearing we are not taking up now.
May I, my lords, kindly leave to mention item number 19 on your lordship's list today, my lords. This is that Shalimar matter which was being argued by Mr. Bachawat, my lords. Mr. Bachawat was supposed to resume his submissions. This matter was supposed to come on last Thursday, my lords, on 28th, but it has appeared today. My lords, humbly beseech.
Item?
19.
Yes. So what are you mentioning for?
My lords, Mr. Bachawat is not here this
If it
week.
is called on before time, we'll
I'll
grant you time. Inform the other side.
my lords,
Your Lordship, I'm appearing.
if it
Your
could be
Lordship,
adjourned.
Let it be called on. If it is called on, only then. Yes.
Very well, your lordship. Great.
Yes.
Application and
May I be permitted to mention?
Application, yes. Application, yes.
For inclusion, my lord.
Of-
WPLR matter. For inclusion, my lord.
Is it an application or hearing?
No, my lord, for hearing.
Hearing we are not taking up now.
Lordship, application.
Yes. Application we said yes. Yes. Next.
My lord, may I just mention one matter, my lord?
No. If the same matter, no.
My lord,
No hearing now.
not correct materials was supplied. Well, I'll hear it out for some time. My lord, this is a writ petition that has been filed by the state. My lord, they have challenged two sets of order, my lord, where in one order, my lord, a contempt rule has been issued. And in another order, my lord, they have been told to show cause and as to why the record of right should not be changed. Based upon an order which was passed in the year
We are
1992.
telling the
my
merits of the case. We are not taking up the hearing matter right now.
My lord, I understand, but because of this, my lord, the
Understand, please? No. Yes.
Very well.
Call on the list.
great.
Grateful, my lord.
Lordship, I appear for the appellants, Your Lordship. We want to withdraw this appeal, Your Lordship, because it has become infructuous, Your Lordship.
And counsel for the appellant submits that the matter has become infructuous, and accordingly, the appellants do not want to proceed with the same further. Accordingly, MAT 101 of 2022, along with CAN 1 of 2022, are dismissed as infructuous without an order as to cost. Interim order, if any, stands vacated.
Grateful, Your Lordship.
Thank you. Yes.
Not virtually, we have concluded the arguments on the last occasion.
Yes.
Your lordships only wanted to know, if I'm not wrong, my lord, in regard to claim of Mr. Ghosh.
Only certain fact I have gave to your lordship on the last occasion that the plot number is total 2 acres. That is almost 200 acres.
So you have some share.
I have some share.
Yes.
That is my case.
Shandal, what is your?
Now, I first point, your lordships, my learned friend has not questioned the order.
That's you took the point.
That's I've taken. So, my lord, if the writ petition goes, my lord, nothing remains.
But
It's for
factually, it was for factual.
Factually, I tell your lordship,
correct.
he is correct. Some portions, that's all. But so for Majid Khan, your lordships, that absolutely no dispute. So therefore, there is, my lord, even if your lordships goes into the contention of my learned friend Mr. Ghosh,
Yes.
even then your lordship, Majid Khan can be, my lord,
Mr.
clear.
Shanal will request you to file short written notes of arguments in this. Very short written notes of arguments. Hearing is concluded in the matter. The parties are requested to file their brief written notes of arguments on the returnable date. When would you like to file?
My lord, 2 weeks time, my lord. or
2 weeks.
1 week. 1 week. My next Monday will.
Next Monday, your lord.
If you can do it by next Monday, otherwise
Monday.
Next month.
For such purpose, the matter will be listed under the heading to be mentioned on September 8, 2025.
Get.
Next.
I am getting on about the
When is it expiring, the interim order?
extension of interim till 30th August. It
30th
was.
August? 30th. What?
I have served.
We'll extend it for a limited period, Mr. Galib, and we'll put it on the hearing list.
My lord, in this matter, I beg to appear for the respondent number
Yes.
59. My lord, the extension of the interim order has, my lord, no copy has been served upon us, my lord.
Extension, they have filed an application.
I do not know, my lord, this matter
no.
is appearing
No
before this
application.
court for the first time, my lord.
So what?
My lord, no communication that they have
You should
mentioned.
have given a notice that you'll pay for extension. Should give a notice.
My lord, notice has been served upon the, my lord, yes, I do not know that, no, they have not given any letter to us that he is appearing, my lord. State
Whenever
has
you appear in a matter, give a
I
letter to
have
the
given
appellant that
notice
you are
to the
appearing,
state.
so that further communication can be made to you. Is correct.
State has received the notice.
Affidavit of service filed today be kept on record. Full stop. The interim order granted earlier is extended till November 15, 2025 or until further order, whichever is earlier. Full stop. The matter shall be listed for hearing in the monthly list of November 2025.
My lord, there is, my lord, the order that was passed by the learned tribunal. My lord, the next date before the SDO is in this month, 16th. My lord.
State,
That is why we have extended the stay. That is the precise reason.
My
Next.
lord can fix a shorter, my lord, matter is very short, my lord.
We are also short of time. Next.
Tendering by unqualified apology. In item 2 and 3, may I be permitted to file the writ petition?
2 and 3, what did you do?
Copy of the writ
2
petition.
and 3, what did you order? What order did you pass?
tenders of arguments were directed to.
Filed within Monday. This is the copy of the writ petition.
File with your written notes when you take up the matter.
My-
510. My lord, in this matter, my lord, I beg to appear on behalf of the,
Yes, this is 5. Yes.
my lord,
State is the appellant here,
my lord,
and rather the petitioner. Yes.
my lord, I have served, my lord, all the respondents. Affidavit service কে দুটো করেছে না? ঠিক আছে, দুটো করা আছে।
Ready?
My lord,
You have checked up, all have been served.
yes, all have been served.
Wait, one is a copy. Mr. Bhattacharya, you are appearing in this matter. Mr. Subroto Bhattacharya, you are appearing in this matter. Yes. Yes, Mr. Mahato, what is it?
My lord, this is the case, my lord, there are 3 judgments.
Right.
My lord, this is the larger bench judgment of the tribunal.
What is the matter about?
My lord,
What is the matter about?
this is matter about the vesting under the West Bengal State Requisition Act. Original Riot did not submit to retain his land by submission of B form. 6-1 proceeding was initiated. Sometimes appear, sometimes disappeared. Ultimately, vesting order was passed. Thereafter, the sons, both the sons of the original Riot came to this honorable court. They claim that they have filed return in 7A, and the High Court directed to consider the same. That was not considered contempt. Thereafter, punishment was given to the BLRO. Again, my lord, the High Court read demanded. Thereafter, order was passed. That was the subject matter of challenge before the Land Reforms and Tenancy Tribunal.
What was done by that?
My lord,
By the order, what was done?
by that order was done that as the Riot did not file return in Form B, claiming his possession, but section 6(3), the my lord, section 6 of the state requisition that in respect of there are 3 provisions are there: 5 acres of agricultural land retention, 15 acre of non-agricultural land, it must be within possession, and 25 acres of agricultural land possession.
Publication of notice and all these were done properly.
These were done.
So what is your grievance against the order? What is your ground of challenge?
In this case, my lord, my ground is
We are only speaking about this case.
my lord. In this case, my lord, if your lordship kindly come, page 15.
Yes.
My lord, here my lord, the return was submitted. Kindly top of the line. Brito অঘোরনাথ মন্ডলে দানপত্র মূলে পশ্চিমবঙ্গ দানপত্র মূলে that the deed of gift is not executable. That is the finding of all the 3 members of the argument. But they said that it may be treated as his son. he can claim the file the return on the date of vesting. But this is the, my lord, total kindly see that this return, how this can be considered. Danpatra Mule, the Danpatra, the deed of gift was executed in 1958 after the date of vesting.
This point, how was this point dealt with by the tribunal?
Tribunal, this, my lord, kindly come, my lord, the
Point number one is this issue.
yes, the issue was that, my lord, that either his son or the legal heir, he can submit the return. But the deed of gift, they said that it is not acceptable.
But his filing were accepted in the capacity of son.
If he filed accepted, but he has not filed in the same. If he would file the said at the capacity of the son, that could be, my lord.
But even if you don't go by the gift deed, he is the son. So therefore, that capacity remains. Whatever
my lord,
capacity
then my lord, form ought to have been, my lord, corrected.
That's technical.
Yes, it is technical. The point is technical.
Yes, we appreciate that proper form has to be, but then opportunity could be given to.
And another thing, my lord, both the, my lord, all the judges has passed the order in the prayer in the original application. There was not setting aside the judgment of 1969. No prayer, no averment. That has been set aside. That vesting order has been set aside. That could have been molded. Prayer could have been molded.
How could it be molded?
My lord, they could have been given.
If the vesting order remains as it is,
they could have given opportunity to amend.
If that vesting order remains, then how could that be?
That cannot be.
They cannot retain then.
Well, that is
has to be.
There has to be. But then the petition.
What is your defense against that order? We don't understand you. Oh, that is your only defense, that gift deed on the basis of gift deed.
On the gift deed, my lord, he cannot.
But otherwise, on the basis of as son, he could.
As a son, he could.
Then
as son, he could. But another thing is that on the date of vesting, which land are in khas possession, that can be pleaded by the Rayat. His Rayat was existing on that of time, but his son can also say that we are in possession. But that was
independently in their capacity as sons also they can say.
They can say that his father is in possession. The form ought to have been filed in the capacity of his retention of his father, not in his name. Well, the objection is that he filed the return for his on the basis of the deed gift, but the return ought to be filed in the name of HON'BLE, the Rayat.
It has to be hard on merits.
My lord, it is to be hard on merit. Because one thing is very difficult is my clerk has not marked the page marking of all the three judgments. Both are lengthy judgments. As it is certified copy, judgments have not been
certified copy cannot be marked.
Certified.
That is right.
Yes. But
it has internal pages.
Internal pages.
So let us admit and direct you to prepare paper books.
My lord. Well, I have annexed all the documents. This
this appeal to be heard on these paper books.
My lord, this all order.
The city was there. We could pass that order.
My lord, other side, my lord, I
will have to give them opportunity to file opposition.
My lord, surely, my lord. In this case, my lord,
the factual questions are also involved.
Factual disputes are involved.
Learned counsel appearing for you are the senior. You are also a senior government advocate. What is your designation?
Additional government pleader.
Additional government pleader. So that's that is above senior government advocate.
Above senior government.
Learned additional government pleader. Learned additional government pleader contends that the learned tribunal erred in law in affirming an order whereby the application, the returns filed by the respondents, on the strength of a gift deed executed by their deceased father was allowed. Fusab learned AGP further submits that although in law, the respondents might have had a better case if they had filed the return in the capacity of the son of
On
the
behalf of the riot.
son of the original riot on behalf of such riot, comma, such benefit was not available to the respondents on the basis of the gift deed. Full stop. Since such arguable question has been raised in the matter, comma, the same is required to be heard on merits. Full stop. Learned AGP submits that all the relevant documents are annexed to the application itself. Full stop. Next para. Accordingly, we are not directing formal filing of affidavits, formal filing of paper books. Full stop. The respondents, comma, despite service, comma, are not represented today. Full stop. The affidavit of service filed today be kept on record. Full stop. The respondent that shall file their affidavit in opposition, comma, if any, to the writ petition within September 19, 2025. Full stop. Reply, if any, shall be filed by September 26, 2025. The matter shall be listed for hearing on the basis of the affidavits and the writ petition in the monthly list of November 2025, immediately after reopening it.
My lord, deeply applicable.
Not immediately after reopening, we have 2-3 days in between.
My lord.
November monthly list.
My lord. Originally, the chairman said that at the capacity of the son he can do,
Right.
but the member said that no, because you have filed the return in the capacity of.
No, you have a point there because these are different capacities, not
Different
merely
capacity.
technical, may not be merely technical.
My
You are asking for different capacities.
capacity.
As you said, not in the capacity of riot, in their independent capacity. They
My
asked. Yes, next. 6.
My lord, before moving, my lord, I sent on 17th August, but the track report is not yet served.
I am for the private.
You are the only, you are for 6 to 10.
6.
Then I have
On the last occasion, you had appeared for 6, 8, 9, and 10. Except 7.
6, 8, 9, and 10.
What about the others? 1 to
7.
5 are state authorities.
I am there for 1 to 5, my lord.
But then
others.
so there is anyone beyond 10, Mr. Lahiri?
No, my lord.
No,
So only
because they are-
7.
No, the remaining, they are having additional party application pending before the tribunal. That's why they are very much there to contest, I believe, because they are the patta
No,
holder
there are others. There are others.
Yes.
11 to 14.
and they have their,
They are the patta
Yes.
holders.
they have the,
11 to 14 have to be.
they are patta holders and they are having an additional party application pending. They
We
prefer.
cannot wait indefinitely. You have to
How
serve
can it?
properly.
Sure.
Well, I sent, my lord. Are you ready?
So you are not enjoying any interim order.
No,
Virtually expeditious, my lord.
only experience.
Experience hearing of what?
What everything, my lord.
The application.
Everything is
Of the
Since
application.
2022 is
Also,
pending.
interlocutory applications pending. He
2022
preferred one
is
injunction
pending.
application.
before the tribunal.
Tribunal.
Kindly see the last page, my lord.
108, page 108.
Not yet passed any order, my lord.
Wow.
108.
MA 905, my learned friend's
That is
application for
my-
injunction.
39.
No.
Yeah.
MA 905 is injunction application preferred by learned friend for the petitioner.
39 is
39, I don't get any hodish.
316.
316 is for additional
Additional
party by this private respondent, page 9.
Clients.
These two are pending along with original application.
Since 22,
so we can direct the what will be a reasonable time for directing these applications to be heard of.
my lord.
411 is the date.
411 is the date.
411.
My lord.
411 is
Ito,
date.
kindly see the last line of the order.
so positively taken up for hearing on that date
My lord.
and disposed of by the end of November.
My lord.
That would be, we think, a
My
reasonable-
lord.
Applications.
applications.
My lord.
To file your affidavit of service. Affidavit of service filed today be kept on record. Full stop. Apart from respondent number 7, comma, all others are represented through counsel. Full stop. Next para. The
2 p.m.
innocuous, you're not filing it?
No, affidavit service after 2 p.m. my lord. We are not affirming that they are not.
Tell us that.
My lord.
প্রথম লাইনে যেটা বলে affidavit service file করে
My
leave is granted to the learned advocate for the
petitioner.
petitioner to file affidavit of service during the course of the
My
day.
lord.
Full stop. Despite service, none appears for the respondent, although the other respondents are represented through their counsel. Full stop. In view of the innocuous nature of the order proposed to be passed, comma, further service on the respondent number 7 is deemed not to be required. So next para, the petition, several applications in connection with OA 3581 of 2022 within bracket LRTT bracket closed, being MA numbers 905, 39, 316 of 2023 are pending since quite some time before the fourth bench of the West Bengal Land Reforms and Tenancy Tribunal. Next para, in view of the long pendency of the matters, comma, the ends of justice require that the matters should be disposed of expeditiously. We are prepared, we are apprised by learned counsel that the next date before the tribunal is November 4, 2025. Accordingly, WPLRT 134 of 2025 is disposed of by requesting the fourth bench, comma, West Bengal Land Reforms and Tenancy Tribunal to take up for hearing all the pending applications bearing MA 905, 39 and 316 of 2023, comma, pending before the said bench in connection with OA 3581 of 2022 within bracket LRTT, positively on the returnable date, that is on November 4, 2025, and to dispose of such applications by November 30, 2020. We'll give some more time. By December 15, 2025. Full stop. No rest to cause, certain certificate copy.
Well, addition of party application may be taken up first. Thereafter,
That we are
injunction
not directing, tribunal will decide. You can argue before the tribunal.
kindly one-liner, because if the injunction is decided, we are the parta holders. They are seeking injunction against us without making us party. That is why we have come as addition of party.
The other that is the discussion of the tribunal, Mr. Lailu. We won't direct the tribunal.
Then kindly grants me leave to make that prayer before the tribunal.
That leave is always.
Well, indication, well, if the
We have
tribunal-
directed all the
injunction is
applications.
prior.
We have
Injunction
directed
is
all
prior.
the applications to be taken up for hearing on that date. So you can make your argument there.
If,
Oh,
well, there is an order of High Court, well, the tribunal.
Yes, the High Court's order is that all the applications will be taken up, including your application.
Chronologically, I'm coming after the injunction application. If the injunction application is allowed, then well,
One is injunction. What is the other?
other nine addition of party. Mine is addition of party. C16.
No, Mr. Lahiri, if the tribunal feels that addition of party requires some hearing, immediately the property should be protected, then tribunal may do it. We won't interdict with that discussion.
Take a chance before the tribunal.
Right. Next. Yes.
So, my lord, I appear for the petition.
Yes. What is the challenge against?
One of those very sad cases, my lord. Before, my lord, I make any submission, dismissal of my application on the ground of, my lord, limitation, restoration application dismissed.
Why sad?
My lord,
Sad for your client.
sad for my client, my lord. I'll be honest with your lordship, my lord. There is
Huge delay.
Huge delay, and there is lacuna on the part of my client. Lord, my lord, for substantive right, if your lordship, my lord, permits it, my lord, I leave it to your lordship upon imposition of cost. My lord, I've told my learned junior, this is one of those cases where cost should be imposed.
We understand, but state is the only contesting respondent. Main
Private respondents are there, my lord, have served everybody, my lord.
served everybody, received. Yes, what is the delay? Let us see.
My lord, the initial delay, your lordship will find, my lord, what has gone down wrongly in the order, if your lordship
Yes.
kindly sees, my lord, it was the illness of my wife. But it has gone down in the order that it was my illness.
Acha.
That is why, my lord, the contradiction came.
Let us see the impugn order first.
Yes, my lord, kindly
Let
take
us come to the second page.
Yes.
Delay in filing the internal page 2. You
Internal
can
page.
refer to the internal page. Delay
So
filing.
there is delay for 22 days.
At least 2 days extra. Otherwise, it could be disbelieved on the agreement. Stating it due to illness of his wife. Tribunal
Yes, but
says
what has gone down wrong, my lord,
could not
in
contact.
the
his-
typographical error, there was.
You produce some documents regarding illness of
Yes.
what sort of illness?
What has happened, my lord?
What sort of illness? Cough and cold.
No. She was suffering, my lord, from chronic disease. She was having fever, having stomachache, and it was prolonging for a very long time.
How long? For 22 days?
For 22 days, obviously not. That is what I am saying, my lord. It cannot be for 22 days. Otherwise, she would have died by that time.
Let us not say that.
I'm being very honest to myself, my lord. I have said this question. How do you justify
No, no,
422
medical
days?
certificates were annexed.
Medical certificates are annexed.
Chronic ailment, what is the nature of what is the name of the disease?
No, I have found out, my lord. Kindly cease, my lord.
One of the tests is if the court cannot understand the name of the disease, then generally it is allowed.
Kindly see page 45. It's a restoration of restoration.
Oh,
That's why, my lord, I said conduct wise.
Page 45. Kindly see, my lord, paragraphs 3 and 4. I find my learned tribunal is not wrong in saying anomalies.
there's a
That
fever
is
of
the
his
reason,
wife
my
is
lord.
coming
There
up.
was a typographical error, my lord. Inadvertent
Fever of his
typographical.
wife was
Wife's illness. In for my illness.
That cannot be because, my lord,
That's why anomaly.
that was argued, my lord.
too worried to look after the matter. And nothing. No, paragraph 4 is dismissed due to ill luck.
My
of the
illness.
petitioner.
My illness.
This
His
is the
illness.
typographical
Ill
error.
luck. L-U-C-K. Luck.
Ill luck due to ill luck of a petitioner.
Not
Oh, if
illegal.
your application. That we may constitute to be an error, but medical certificate, where is the medical certificate?
Starts from page. No. Achha. Copy it.
It's there, Lordship.
There, medical certificates are there.
Was starting from Millard,
Page
117, 118, Millard.
118.
Starts from 118
Where is the diagnosis? We are
up to Millard 133. Up to 133. 118 to 133. I leave to your Lordships.
hypertension, ischemic heart, angina. All of us probably have it, at least during court hours.
I said to your lordship, my lord, I cannot improve something which is not there on paper.
There is no error here. What is the challenge against?
The challenge is against an order.
Challenge is against 34 and 40. Page 30. Two notices by the Thika tribunal. Thika controller, sorry. Page 34 and page 40 are the two challenges.
Yes, for
2013 notice.
so this is a notice. You appear and to take your points there.
Yes, my lord. If your lordship remands it, then only, my lord. Today I am nowhere because my application
Is no more on the file as on date.
No,
Whereas
that notice. What was done pursuant to it? Orders have been passed.
and I have not taken the update.
No,
That
no,
is a challenge in the way.
We are not interfering. A notice challenge করেছে secretary secretary ওখানে কি তো বলতে পারছে এটা frivolous.
But my lord, I have to
Frivolous.
for the, my lord, tribunal itself. Because otherwise, man, there's no other way out. That is why, my lord, I said to your lordship.
There is a question of challenge to a notice. Appear before the Tika controller, take all your points. That does not amount to submission to jurisdiction. You take the jurisdiction point if you feel that it's not a Tika proper.
Lordship will dismiss with the liberty, my lord, then I
No,
shall.
why will why will
Something,
In
something to, my lord.
we'll-
that is the challenge in the way. Kindly see
rather,
page 19.
That is the challenge. in
Page
the-
19, those are the two notices under challenge. Page 19, kindly see,
Something which your lordship could, my lord, perhaps
Against those.
grant.
and nothing else. Kindly see page 19, that is the part of the original application, particular orders against which I am before the order.
order
dictated-
dated 7/8. Where is the order?
He writes the order, but that is not, that is 7, that is page 40.
Where is the 7/8 order?
Page
7/8
40,
notice.
Page 40,
Oh, 40.
page 40. It's notice.
No, no, even on merits, we don't find anything. You say there are merits.
Notice.
I did not say, my lord, there's merits, my lord. Only substantial rights to be determined. Now I leave it to your lordship, my lord.
It's also a
In the
notice.
challenge which you preferred, no substantial rights will be decided. You have
Because, my lord,
challenged the
claim
notice
is, my
only.
lord, purchase the property. Subsequent.
Yes, but notice does not mean substantial rights are decided. If you're substantially your rights were decided, then it would be a good challenge. No, sorry. We are
Page 40 is also a notice. It's
The
not a-
present writ petition has been filed against an order whereby the tribunal has dismissed the second restoration application of the petitioner upon the dismissal of the connected application for condonation of the delay in filing the same. Push up next para. It transpires from the materials on records and upon hearing learned counsel for the petitioner and learned senior government advocate that this was a second instance when the OA, that is OA number 3162 of 2014, comma, filed by the writ petitioner was dismissed for default. Full stop. Next para. The flimsy ground taken in the condonation application is also contradictory, full stop. Whereas in paragraph number 3, the petitioner cites the illness of his wife, comma, in paragraph number 4, he cites his own illness for the delay. Full stop. Even if, comma, taking a liberal view, comma, we were to construe such dual mentioning as an inadvertent error, comma, the purported illness of the wife is not described clearly in the application for condonation of delay, comma, nor is it borne out clearly by the medical documents annexed, comma, to be of such a grave nature that the petitioner could not attend his own application before the tribunal. Full stop. Next para. Moreover, comma, the premise of the explanation in the condonation application, comma, rather than being the petitioner having to attend his wife or take her for treatment, comma, is that the petitioner was worrying for such illness of his wife, comma, which is by itself, comma, quite unacceptable as a valid ground. Full stop. Next para. As such, comma, we do not find any illegality in the impugned order of the tribunal dismissing the application for condonation and consequentially the second restoration application. Who's up? Next para. Even if there was strong merits evident on the face of the challenge, comma, which was of such a high nature that we ought to have taken a lenient view in condoning the delay, comma, we find that the parent challenge was against 2 notices issued by the Thika controller, comma, by which no substantive rights per se were adjudicated. Full stop. Hence, comma, there is no scope of interference with the impugned order. Accordingly, WPLRT 136 of 2025 is dismissed on contest without any order as to cause.
Only one indulgence, if your lordship permits, the petitioner can proceed to challenge. Since no adjudication on merits, there's no.
No, our ground is that there no substantive rights have been decided. So,
if I now challenge the notice,
will not reopen anything which is not. It is made clear that the merits of the contentions of the petitioner or the respondents in the Thika tenancy proceedings have not been entered into by this court.
I'm grateful.
This সংখ্য এটা আগেরটা কিন্তু ইয়ে হবে জাজমেন্ট ফর্মে হ্যাঁ এটা WPLRT. Yes.
This is a restoration application, lordship.
Restoration by us.
And for the appellant, lordship, this is a matrimonial suit. It's
Restoration filed within time.
Within time. Application number can 7, lordship, within time, but it is not traced out. So further, I filed an restoration application and section 5, lordship. Kindly.
5 and 6. Can 5 and 6?
No, lordship. 7 and 8. 8 and 9, lordship. I have already filed. But 7 has been filed earlier.
In 7 you have stated that
not traced out this application, lordship. So
that you have stated in 7 that you could not trace out.
I do not find out this application, lordship. So this application.
No, in your new application you have stated that you had previously filed an application for default.
No, lordship.
Then
Can 7 kindly see for a moment, lordship?
Can 7 we are having Can 7.
That within time, lordship.
Pardon?
The matter has been dismissed for default on 28/11/2022, lordship. Matter has been filed with.
You have not stated anywhere that you had filed a previous application.
No, lordship. Can 7 within time has been filed, possibly.
Oh, acha. Can 7 is before us.
Lordship, kindly for a moment, lordship, kindly see this.
Can 7, yes.
This is a restoration application.
28th November 2022.
Lordship.
So, and you have filed this. Yes, this is within time.
Lordship, this is the misplaced, so I could not file further file and Can 8 and 9, lordship.
So Can 8 and 9 we are saying you are not pressing and we'll allow 7.
Lordship, grateful, lordship.
Notice to the other side. What about notice to the other side? They were present when the matter was taken up.
Notice. I filed a notice. Notice দিয়েছেন এটা application যে আসবে.
Copy of application has been served.
Application has been was.
Where is the affidavit of service?
Affidavit service কোথায় আছে?
Education service.
Affidavit service.
আছে. It happens to be the uncle of the client.
We're along here. Can learned counsel appearing for the petitioner submits that can 7 of 2022 is an application for restoration of FA 81 of 2013. For some next para, since the said application initially could not be traced out in the department, for abundant caution, the appellant had filed can 9 of 2025 for restoration with the self-same prayer, and can 8 of 2025 for condonation of the delay in filing can 9 of 2025. So next para.
Can 8 restoration application, can 9.
No, it's the other way around in our copy. You have captioned it wrong. For next para. Since can 7 of 2022 has now been traced and is before us, learned counsel for the appellant stroke petitioner does not press can 8 of 2025 and can 9 of 2025, full stop. Accordingly, can 8 of 2025 and can 9 of 2025 are dismissed as withdrawn with liberty to the petitioner to sue on the self-same action by pressing can 7 of 2022. Full stop. Can 7 of 2022 has been filed in time. Full stop. We find from the order sought to be recalled that neither the appellant nor the respondent were represented, thereby giving rise to a situation as contemplated under Order 9 Rule 4 of the Code of Civil Procedure. Full stop. Applying such principle, prior service of notice to the respondent is deemed unnecessary. Full stop. Since sufficient explanation for the delay has been given, এক্ষুনি লিবার্টি দিয়ে দিচ্ছি। আচ্ছা, সেন্টেন্সটা শেষ করি। Is given in the application, can 7 of 2022 is allowed, thereby recalling the order dated November 28, 2022 and restoring FA 81 of 2013 along with can 5 of 2022 and can 6 of 2022 to their original file and number. Any interim order was there?
Interim order ছিল?
No, there is no.
Acha, one grave error is there. In the cause title as well as the body of this application, you have given my learned brother pointed out, my learned brother was the junior partner on the bench. You have given the name of the junior partner first, then Justice Showman Sen's name. See your caption, your cause title.
I haven't.
We are giving you leave, correct it right now.
Lordship, I have not.
Leave is, prothom ja bolam tar age prothomei, leave is granted to the learned advocate for the petitioner to carry out the necessary correction in the cause title of the application bearing can 7 of 2022, thereby reversing the order in which the names of the honorable judges comprising the bench which dismissed the matter for default has been mentioned.
Here and now I corrected this.
Yes.
Lords.
Please correct it right now. Can 7. It's in the reverse order. It's also there in the body. We are not. Okay, correction. Next. এটা নিন। এই হ্যাঁ, ভালো হলো দেখলেন আপনি। আপনি বোধহয় দয়া ভাব আছে বলে। Yes, what is it?
I am standing here because in one matter I am appellant, in the cross objection I am for the respondent. So I am standing here.
Oh,
It be heard, my lord, in both ways because I represent the state. But I have already my submission has already been recorded. I think
your submission has been recorded
in the order itself.
One order.
The improved order. Because
want to
yes.
Restoration application.
No,
order.
Impugn order before the tribunal.
No tribunal.
Yeah,
Oh, this is it. Let us see the impugned order.
My lord, I think, my lord, my submission is
Final
not
order.
required.
Impugned order বলেছিস কালা হয়ে গেলি নাকি
Impugned order is
in the impugned order everybody's submission should be recorded
168.
168, yes. What was done?
No, I think it will take 2 minutes time to dispose of this.
ও তাহলে বলে দে
না আমার কি আছে আমি তো মানে আমি যেটা স্টেটেড হয়ে বলবো
Cross objection is there. What was done by the impugned order? Self-help group? You are a self-help group.
well kindly come to the prayer
You are a self-help group. Who is Mr. Basu?
Distributor, petition respondent. He is the respondent.
No, respondent is who? Yes, yes, Mr. Basu, what is the matter?
food marketing I am for the Kulpali food marketing
Applicant in respect of a vacancy.
well we are only my lord agreed the last part of the impugned order
What was done by the impugned order? Let us just see.
kindly come to the impugned order prayer kindly come to the prayer page 28 kindly come to para 28
Page 20.
Page 28 and 29 28 as is my lord a read in the mandamus Justice Kumar Gali got it
Yes.
Condition number 5 of the vacancy declaration notice is such and such issued by the district controller of food and supply 24 Parganas ultra virus to article 14 19(1)(g) of such and such
Reference to self-help groups.
that is your lordship will get at page 34 kindly come to 34
Page 35.
it is very difficult to read for my lord 34 it starts the
34.
notification 17 September July 2019
Yes, 5 is next page.
kindly come to next page
Must be financially solvent. Achha, this is for what? What purpose? What is the, what we do?
the
Distributorship.
the my lord clause
Oh,
5
food suppliers.
clause 5 has
Ye-
been amended
This is the amended one.
amended one no this is
Original.
original one
The applicant must be financially solvent so as to run the
run
distribution
the distribution business successfully having bank
balance of rupees 50 lakh.
50 lakhs
As working capital as reflected of the day of appointment.
Application 1 day preceding the day.
And 1 year preceding thereto.
So the previous day you had to have 50 lakh, the date of the
no,
application.
this is the my lord amended one kindly come to page 121 I want to make it short for my lord
This was the original 35.
kindly come to 121
121.
yes
Yes.
কোনটা
5 lakh.
but
50 lakh was made to 5 lakh.
yes application of distributorship must have bank balance of at least rupees 50 lakhs as working capital as reflected on the day of application
5 lakh for dealer.
this 5 lakhs for dealer
As day on the day of the application, 1 year preceding the date of application. Must have bank balance of 50 lakh as working. What does it mean?
kindly come to 1B second one the
1 and
application-
2, it's 1 and
application for distributorship we are concerned with distributorship
Acha, acha. Must have bank balance of at least 50 lakh as working capital as reflected on the day of.
Application.
Oh, for the last 1 year you had to have, not on the last day.
this is the amendment one this is the amendment
This was challenged.
Original.
this was
not
Amendment was challenged.
this was not challenged that I'm saying
Then what
this
was challenged?
notification has not been challenged
121 has not been
not
challenged.
been challenged without challenging that can this prayer be granted
Yes, that is.
What was challenged? The previous one, unamended.
yes
Yes, this is.
Unamended was challenged.
17 July
Neither of you pointed out.
yes
What was the reason for not doing?
Well, kindly see that reason.
We are noting carefully because you will do the same thing when you go against our. Your expressions are being noted, Mr. Vasu. Whenever you challenge an order, we are noting your expressions because we know that when you go up in further appeal before a higher forum, you will make the same expressions. So be careful on that.
Kindly see the.
No, why was this done? Let us see this.
Kindly see.
my lord should I say
Yeah,
live stream is going on that's why women self-help group
That we can understand.
that's what a sympathy with
We also have a sympathy for women.
everybody Justice Kumar is not saying anything I don't know what about
Just
him. Saying so I don't know what is about him.
Going on in court number 24.
Sympathy, let us see. Sympathy.
No, my one matter is going on, man. I can 24. I'm coming back, madam. My
You are in this matter.
Cross appeal.
Cross appeal.
We have seen you. That is
Your Lordship has seen me. Yes, not the order.
no order we are looking. No. How was this point dealt with that this has already been amended? Is there any? Have you pointed out? Is it reflected?
In my
What was the relevant page?
submission.
Kindly,
173.
173.
Mr. Bhattacharya, Pingal Bhattacharya will hear you last because you're the writ petitioner. You have to answer.
173 kindly come. Page 173, internal page 6.
Yes.
This is choking, my lord, kindly pardon.
6.
173, paragraph 6. The respondents was specifically directed to fill up the vacancy in accordance with the control order of 2013, the earlier division bench order. The relevant part of the division bench judgment, however, reflects that emphasis was placed on the preference given to the women-run self-help group in the 2013 control order. Therefore, it is clear that the division bench consider the preference to women self-help group in 2013.
But women self-help group has not been challenged.
This is also challenged.
No, but the amended notification also says women.
Two part. One is women self-help group, another is financial capacity.
Oh, the unamended provision
Yes.
specifies women self-help group.
No, my lord is no. I will not disturb.
No, my lord,
Can
says-
come to the bottom. Can come to the
Kindly
bottom.
consider one thing.
Can come to bottom. Admittedly, the word starts with admittedly. It's my fault. I was arguing one point and showing to lordship another point. My lord got admittedly.
Page 6, internal.
Last line. Admittedly.
Yes,
admittedly, the petitioner did not challenge the amendment made to the 2013 control order. It is therefore arguable whether the petitioner can now question the dilution of the preference given to the women-run self-help groups after publication of the impugned vacancy notice in 2019.
No, but 5 amended or unamended does not distinguish between women self-help group and others.
This financial capacity. Financial capacity. That has been jumbled up.
5 says the applicant must be financially solvent to run the distributorship business. So the applicant had to be a women self-help group then. And now also that remains.
The financial capacity only changed.
So the premise was that the women self-help group.
Amended. That is also amended. That I am showing to lordship later. First.
Anyway, let us see. Continue. Admittedly,
This one first.
did not challenge. Yes. 7. Further, the petitioner's condition, the 38 vacancies is published contrary to.
Amendment.
The others given. Oh, there was another amendment to reducing 50 to 25.
Yes. এটা আমাদের দরকার নেই সেটা আমাদের দরকার নেই that is subsequent not for us.
However, the petitioner's grievance
And women self-help group privilege was taken away.
No, division bench category change of location.
Division bench.
There were other grounds also.
No, 2 grounds are there mainly. One is self-help group women giving precedence and another is financial capacity. So far as both are
Financial capacity code does not interfere.
No, both are amended. Now, what happened, my lord, in this case? What way with the court? Division bench passed an order on 25th September 2018. Can you come to page 62?
No, but you are highlighting the financial aspect that was not interfered. The other aspects were interfered.
Both.
662, yes.
Can you come to 87, last part? What this division bench said? As if division bench and irrespective of the amendment or no amendment, self-help group has to be given precedence. That cannot be made.
There's a provision for this.
In view of the aforesaid facts. In view of the aforesaid facts, the impugned order of the laminated trial is set aside. The advertisement of the vacancy notice published by the state on 13 July 2015 are also set aside. Then,
Accordingly, the authority of the state government direct to initiate.
No, the change of location was also another.
This is the main ground there. While considering that ground, this observation was made by the division bench.
No,
Observation
that
is
smacks
just
of
above.
bias, malafide bias.
The observation is just above paragraph.
Third line. Starts on third line.
At the top, third line.
Yes, yes.
It's of the 13 control order.
Provision to
The
preference to self-employed.
provision for giving preference to self-help group. Self-help group in view of the inclusion of the provision for giving.
So that self-help group preference was upheld.
Yes.
And accordingly, decision of the state government to invite fresh applications for grant does not seem to be arbitrary. This is in connection with the unamended
provision.
Acha. Next is only pinching point is issue of change of location of distributorship. That was not there in the notification.
That is not decided at all.
No, that is not challenge.
Two grounds are there, only self-help group and quantum, financial quantum. Self-help group also amended. Amendment.
But self-help group was given preference by
On that point of time,
the
which was
unamended provision.
On that day, my lord, when the writ petition was taken up for hearing the writ petition, this was not the point. Location was the point. Amendment just a minute, I am showing to your lordship.
So the unamended vacancy notice does not speak out women self-help groups. Page 34.
34.
34 does not speak out self-help groups.
No, I'm
We can give this copy out.
No, we are. This is legible. We can.
It is legible.
Yes, yes, more or less legible. We can read. Here, women's self-help group was not given preference. In the unamended provision also.
Yes. Page 13. Page 13.
Page 13, yes.
Page 13 is the notification.
Well, kindly come to
Page
page 13. The notification dated 18 December 2018. Is it my lord?
Yes, 13.
Kindly come to IIA.
Yes.
At the bottom.
Self-help group.
Woman deleted.
Woman is not there. This notification was challenged.
No, the notification is now governed at the date of publication of this order, but the justice division bench, my lord, make an observation.
In the division bench, what was challenged? This notification?
No.
Something else?
The location.
Anyway, location. No, the division bench had relegated the matter, or this was a fresh writ petition?
Only they said to, I have shown to lordship page 87. What is the order?
No, division bench.
Yes.
Director for fresh notification.
Trial judges, what was the judgment of the yes?
The fresh notification must be on the basis of the law prevailing on that date.
Yes.
If that be so, then my lord, the woman strike out.
Directed to initiate steps for issuance of fresh advertisement for filling. Oh, that advertisement was set aside on the ground of location.
Yes, sir. Location was
So location is not a sticking point here.
No.
No. Achha. Very well. Then.
No, my lord, I want to say something here. The division bench was considering the writ petition where the location is subject matter of challenge.
That is what we are saying.
In deciding that, the court made certain observation.
Yes.
Whether that observation is binding, even if binding, whether that can override the statute prevailing on the day of subsequent publication. This is the point to be decided.
No, but the division bench, when the division bench order was passed, the amendment had taken place. No, further amendment. 121 had taken place. If you have inclusion of provision for giving preference to certain groups, it implies that the zone of concept. That's an observation.
That's what I'm saying.
No, let us be clear on this also. Page 13 is the notification, the original notification.
My lord.
Previously, there were women's self-help groups.
Yes. Women was
that
there.
women was removed by this notification. This notification is not also not challenged in the present writ petition. Our case. So that notification virtually removes the women from the
My lord.
self-help group.
Another is removal of women from this notification, not challenged, and other is financial,
Subsequent.
not challenged.
So what? Only 5 was challenged.
Yes, only 5 was challenged.
Writ petition prayer you placed which page, please? Again?
Kindly come to page 28. 28.
28 is. What are the other prayers we want to see?
Other prayers, my lord, the
Vacancy cancellation.
vacancy cancellation.
Uh,
If the first goes, the vacancy automatically go.
on that ground only.
Consequentially.
Consequential. So only that money requirement was challenged. So
That has been amended.
yes.
Amendment is not subject matter of challenge. In both the score, women's score and financial score, both the notifications not challenged.
5 lakh was challenged before this court. 5 clause 5, 50 lakh. 50 lakh on the previous day, which was made to 50 lakh previous year.
My lord.
50 lakh over previous year was not challenged, only previous day that was challenged. That was the subject matter before the single judge in our case.
In this case.
Actually, let us see how then why these considerations, the other
consideration on the basis of the division bench.
Petitioner's case is that vacancy notification data does not give preference to self-help group. They made out that case before the court.
Right. Whether that can be granted after the amendment without challenging the amendment. Can you see the amendment is not challenged, under challenge, not causing the amendment?
But the learned single judge's observations begin with the very next sentences. Petitioner has challenged.
The notification by
But
which
that was not challenged actually.
amendment which was they are not been challenged. Only my lord is showing with the court the order of the honorable order. I should not say order, it is observation of the honorable division. And that observation, if you lordship allow me to say, this is an obiter. It is not connected with the main challenge. In short, this is the submission.
Division bench did not direct specifically for that, it to be in terms of that. Division bench directed is directed to initiate steps for issuance of fresh advertisement for filling up the vacancy of such and such.
Because
in accordance with the provisions of the distribution system.
Because of the fact that the notification was cancelled.
But the division bench also did not direct specifically that it had to be in terms of that amended notification, unamended notification.
Observation, but this is not the issue before the court.
Mr. Shah is leading you.
We have prepared a short compilation of what I have said. If you it might help, my lord.
Copy
this is already handled.
Paragraphs are also mentioned.
Therefore, it is clear.
Okay, that's it.
Mr. Bhattacharya, you could have challenged the amended notification. Or the notification itself, you have not challenged in the writ petition. You have challenged only clause 5.
Let me place my case. Let him conclude. The thicker history in this matter, that's why I'm saying let them place the case. They are. Let my learned senior friend place their case.
Clause 26 of control order sections.
দুটোই করেন।
But your amendment contention was recorded.
Everything recorded, but I should say the court has
According to the state, he has a preference to the request for the amended right. Yes.
According that, my lord, the conclusion is
But let them conclude their submission. Let That would be better, my lord.
Yes.
Instead of this one.
আসবে না
Other grievance with regard to requirement.
ভাগ করে দে দুটো করে
তুই বলবি তো শোন কতক্ষণ বলবি শোন না তুই কতক্ষণ
In fact, the petitioner's challenge to the latter may not also be sustainable. That has been stated.
যদি কি কোনো that's why the cross appeal.
Please. No, it was observed that the subsequent amendment would not be applicable to vacancies which have already been notified.
That is
So therefore, that amendment is not applicable here.
amendment is applicable. So when the vacancy thereafter declare
There
advertisement.
was already a vacancy notified.
Yes.
You had notified a vacancy.
State government had.
State government had, sorry. But then
On the basis of the vacancy, my lord, advertisement made, advertisement struck down. In end of
kindly see 3 dates. The division bench order and when the vacancy has been notified. They waited for the amendment.
1 minute, Mr. Basu, no. It was specifically mentioned in the amendments that it would not be applicable to vacancies already notified. Vacancy had been notified in your case. So amendment won't be applicable. Therefore, the challenge to the original notification was valid.
Yeah, I don't mention the clear. This is the notification. Kindly read out that notification. Let us see that notification. Notification.
Yes, subject.
নোটিফিকেশন এখানেই আছে
সাপ্লিমেন্টারি এভিডেন্সটা নিচে এইটা যেটা খুললে নেই মানে এই 160 these are not
164.
My lord, kindly come. Oh, sorry.
Yes.
Kindly come to 164.
that is not challenging the execution and supplementary.
The last year.
This was subsequent to page 121.
161.
Yes.
Yes.
It was not challenged. You by way of supplementary affidavit is annexed. The last line. This order shall be applicable.
Shall not be applicable.
Shall not be applicable to the vacancies of distributors associations
Already published.
So this 25 lakh would not be applicable.
Yes.
But there is nothing similar in page 121.
Will be applicable for the
vacancy.
vacancy.
For this vacancy, 121 will be applicable, which has not been challenged.
They had only challenged that 150 previous day 50 lakh notification.
Yes.
Clause 5.
Not notification.
That was the entire scope of the challenge. The writ
Yes,
petition.
my lord is perfectly correct.
But the learned single judge records that they had also challenged the other notification.
I have placed my lord the prayer in the writ petition.
Petitioner that starts with the prayer has challenged the vacancy. Was any supplementary affidavit or amendment in the prayer portion?
No amendment.
But both of you argued, both of you knew that a challenge was also being thrown.
No, we have said, my lord, our service is recorded that this has not been
Challenged.
challenged.
And we have placed judgment also.
And the court has said admittedly not been challenged.
What is that vacancy declaration notice dated 17/7?
77 এর notification আছে এর মধ্যে
17/7 notice.
Page 94.
94?
94.
তো একই যেটা দেখানো হলো
Same, I have shown to you, Lord.
Oh, this is it.
same
Clause 5, my lord, I have shown to you in the other page.
95.
My lord, recall in page 6 of the impugned judgment, court has recorded admittedly it has not been challenged.
And the one which is challenged is at page?
It has been challenged. That is at
Page 35. 30. It's not the same. Looks like the same.
same.
17 July, same.
Twice it has annexed.
So they had challenged this notification only, 17/7 notification.
Advertisement.
Yes, this notification.
No, this is the vacancy. Vacancy, yes, vacancy.
Yes, this was challenged, not the conditions.
Clause 5 of this was challenged.
Yes.
In the
This 5 of this was challenged. But this clause 5 came in terms of the notification of the government. They cannot insert any document, any clause in the advertisement, in the notification. They have to adhere to the amendment of the statute.
But that notification you are speaking of, that is also annexed here. This is in terms of a previous notification.
Yes.
Where is that?
Is that? It is a notification of it. Notification.
Page 121.
121.
121 is that only?
121.
No. Yes, 121. Applicants must have bank balance of such and such. Woman self-help group, when was it there? Before 2014?
Women.
We don't find any mention of any.
Self-help group is there.
The woman was inserted. Taken away.
Preference was given at that point of time. And my lord, after
At which point of time? 21/7.
Because at the time of the passing of the honorable division bench order. That is page start with 62.
No, by virtue of what? There was a notification.
By virtue of the notification.
Where is that notification? Woman, where the woman.
No, that was not wiped out. Because the privilege which
does any notification specifically say
yes,
that
they
women
can also allow. Yes,
that
but
we,
privilege. Sorry.
Does any notification specifically say that women self-help group are also entitled or they will be entitled?
They will be entitled along with others, but privilege.
Where is it stated? Which
yes,
notification?
Yes. Well, kindly see.
We want to see the word woman and self-help group together.
Self-help group.
That is what we are
no,
ask. You can't answer a question directly.
No, man.
Does any notification, any of the notifications say woman self-help group?
No.
A Boolean search in Google.
Yes.
Within inverted
self-help
commas.
group. No, man. Self-help group.
So where does the women concept come in the order? That is what we are under.
Vacancy notification.
Earlier vacancy. Earlier vacancy notice.
Vacancy notification, it was inserted.
Earlier. Being
Where is that?
Statute.
We want to see the word woman.
Previously.
Woman
That is not there. But it is perfectly correct.
Self-help group রয়েছে সব করে।
Self-help group is there. Woman concept came from a
Self-help group still remains.
Still remains.
Still remains.
Still remains.
What has been changed is only this for one preceding year.
Yes. That has been changed. And woman, the concept which was argued with the division bench,
Yes.
which was there in the vacancy notification, not seen the light of the day as an amendment of a statute or the control order.
Oh, there was a particular vacancy notification at certain point of time which was challenged before the
Self-help group.
that went up to the division bench.
Yes.
So that was set aside and directed to issue in terms of the control order.
পরিষ্কার একদম। আমি এত পরিষ্কার করতে পারি।
Yes.
My lord, may I submit only for
yes.
Me to 5 minutes time. My lord, kindly come to page 62. The
I have also relied upon the judgment.
Jane,
what does it say?
Some judgment I have relied upon on the in aid of my.
What is the proposition?
My proposition is, my lord, that.
And if you can give us the paragraphs also.
Yes, sir.
Yes, I have given.
In that
everything is given.
note, in that note,
This is, my lord, the not binding effect of the division bench order. It is a casual remark, not in commensurate with
The 2010-1 SCC went up from the Telangana High Court.
Yes. 2014, 3.
My lord, your lordship wanted self-help group for women group. I am giving that notice. Earlier notices.
We didn't want. We wanted to see whether you have done it.
Thinking,
Your lordship was
really there.
initially.
If it is really there, we have to consider that.
That was.
Why not by a control order amendment? It is by way of an advertisement.
This advertisement was set aside by the division bench.
Yes.
Anyway, we'll. Utterly confusing. Yes, what about 2010-1 SCC 756?
My lord, just a minute.
Just control order.
My lord, the consequential order, my lord, cannot be quashed unless the original order is quashed.
What cannot be quashed?
Consequential effect of an order cannot be quashed unless the original order is challenged.
You are meaning thereby that the original notification was not challenged.
Challenged.
Page 121 is the original. But your clause 5 of page 35,
The consequences to that.
that violates 121.
No, not violates.
No, it does not violate. 1 year. Basically. Same.
And 4 SCC, my lord, formal judicial scope of judicial review. That, my lord, will not be
No,
11.
any particular paragraph?
That is 9, 11, and 12. Which one, my lord?
To 2010 one.
10 SCC, 22 to 25.
Acha. And next you have given 2023 on SCC online SC
This is
1408.
online 671. Hmm.
2023 SCC online SC 1408. That you have handed over.
Kindly please note that 2004 4 Supreme Court cases 19 is in the scope of judicial review. How far the court can go. Paragraph 9, 11, and 12. That's a basic judgment दे दीजिए.
judgment.
बिल्कुल judgment दे दो.
Yeah.
Tinte.
Scope of limited scope.
Yes. How far the judicial review can.
Acha. What other judgment you have?
I am relying on that's 2010. That
Consequence.
2010 you have already relied on.
relied upon, and my lord, the judgment is the 2014 13 SCC.
Yes.
This is a mere observation of the division.
Which paragraph?
Paragraph 34. Varun Agarwala, paragraph 34. Because this was not the least before the division bench or the single bench.
No, that was not even challenged.
No, that I'm saying. This is not the least before the court.
Not before even the learned single judge in our case.
I am saying, according to my reading of the impugned judgment, the court was swayed with the fact that the
Division bench judgment.
said one self-group has to be inside.
Acha, what is about the Nutan Kumari's judgment 2023 SCC online SC? You are not citing this.
That is wrong. No, that is wrong.
এটা ফেরত
কেন দিয়েছে?
এটা ফেরত দিয়ে দিন।
অন্য কারো জায়গায়।
ওটাই করছেন নাকি? 2023
Same point. I am not multiplying.
Same point.
ফেরত দিয়ে দিন। পরে এটা থাকবে ভুলে যাবে।
I am not multiplying, my lord. Same point. But I
Yes.
understand that.
You want to add something?
Yes. Well, whole premises on the basis of which the Honorable Single Judge has passed the impugned order is on the basis of two things. One, the Honorable Division Bench passed an order before making any advertisement, you have to give preference to the self-help group. Number one. This is the whole premises. The Honorable Judge was under the perception, judge under the perception that the order is a null. If the advertisement is contrary to that, the honorable order of the Honorable Division Bench, and that is a specific order, that you have to give privilege or, my lord, whatever protection which were there at the time when the Honorable Division Bench taken note of it. Now, my lord, let us see Honorable Division Bench on what premises the order was passed. My lord, there was a challenge by the other contesting parties who made an allegation to that effect that my right has been accrued in terms of the that advertisement or selection process advertisement. My right has already been accrued. Mr. Bhattacharya appeared on behalf of the petitioner saying that my right has been accrued. So you have to give an appointment. So there is no question of applying for application for in the vacancy notice. So our state's challenge was specific. State made a contention to the effect that the, as per my lord 6, General 6 of the College Act, it is also applicable in the case. In the also, my lord, vis-a-vis clause 8 of the Bengal General College Act, my lord, that unless the right be accrued, there is no question of accrual, I mean right in favor of the writ petitioner therein, in the division bench. So specific submission was made on behalf of the state that I could have understood that if the state approval, that is the highest authority, approved the same, then accrual, yes, he has a case. But the fact remains, there was no such approval by the highest authority at that point of time. So there is no question of accrual of right in his favor. And on the basis, another thing, after that, so many changes have come up by dint of Amendment 2013 Act, my lord, and the amended provisions. So, my lord, taking into consideration of all fact, only the lease was that whether his right was approved or not. And another thing, that the location, particularly you are favoring a person which is arbitrary. Now, my lord, kindly on the premises, it starts with page 62. My submission is very much limited. There was no there was no ratio, so far the Honorable Division Bench is concerned, that before making any further advertisement, as per the Honorable Division Bench, you have to take into account of the whatever rights, that is the preferential right given to the self-help group, that has to be taken into account.
Mr. Shengu, there is one clarification which is required from you. Mr. Basu argued that this women's self-help group was included in the particular vacancy notice which was challenged before went up to the division bench on the earlier occasion, was set aside. Therefore, Mr. Basu, one of the arguments of Mr. Basu is that the premise of that vacancy notice was only women's self-help group. It was not there anywhere else in any notification. And since that was set aside and direction was given that as per control order of 2013, yes. But page 87, the division bench observes that as per the 2013 control order, there is a provision for giving preference to self-help groups, special women self-help groups. So if the 2013 control order itself contains that, and that is the observation of the division bench.
Self-help group. Yes, it is not a women's self-help group.
The division bench records.
No, my lord,
especially women's self-help groups, and directed to issue a fresh vacancy notice in terms of that. Then what is the effect?
My lord, what I am on, subject to my lord's
kind
approval,
yes.
my lord. In the act and the act.
My lord is having another copy has been handed over to my lord. There, my lord will find that women's self-help group is
Old control order
has been handed over to my lord.
Yes.
If you see that, then
This is 2013 control order.
Control order earlier.
Unamended.
Division bench directed in terms of this.
For the time, kindly forget that. Kindly be sure that there was extension of the women's self-help group first ever.
In this control order, where is the term women's self-help group mentioned?
2A. First, be sure of that.
Which 2013 control order is there?
Yes.
Which provision?
Women's self-help group.
Which provision? Which clause?
Clause 20, subparagraph 2A.
Clause 20 is engagement of dealer.
Yes.
Thereafter,
This is distributor. This is distributor, yes, not dealer.
26. 26.
Or I can clarify, in all over West Bengal, women and self-help group, I have annexed the documents. 37 vacancies I have annexed.
38? It was written 38?
All reference to the women and self. I shall show.
Got to know the source of that.
Self-help group chilo.
Especially women.
Yes.
All of you.
Bottom.
All of you, especially women.
2013
এই যে এখানে 26 এ আছে এখানে ক্লজ 26 especially women. So preference may be given to this control order was not modified later.
Yes.
Control order remained.
Control order modified.
That was modified. Modified prior to the learned single judge's order.
Yes.
There women was taken away.
Let,
That is there.
Yes, that was
120.
that's not correct. That's not right. That's what your lord. Let my learned friends.
Where is the subsequent control order? Do you have a copy of the subsequent?
18.
paragraph page 30.
Yes.
Page 13, I've handed over to your lordship. In the brief, 13, page 13.
2018.
That is 18. And this is 13. Page 13. That man will find woman what is missing. That's because to see first whether the existence of women is there or not.
Yes. But this you say was not challenged, this 2018 control.
Just.
And then once what happens to the direction of the division bench that it should be done in terms of 2013
Yes,
notification.
that's why, my lord, I am making.
Yes. But do you, let us start
Yes.
from there.
Yes.
Division bench or direction
Yes,
remains
yes.
then.
My lord, whether it is a mandatory order, before making any advertisement, you have to give the preference to the self-help group or not. This is a question. My lord, upon
Division
reading
bench
the,
director states in your
yes,
teeth.
no, the premises, my lord, has to look as a whole. The judgment has to read as a whole. Where segregation will not be enough. So, my lord, one of the point the state has taken in this division bench appeal that, my lord, kindly consider that the right has not been accrued because the state government at that point of time did not give his approval as per the statute, so no right has been accrued as per General Causes Act. And second submission was made after that.
Once again, this was not there when the division bench order was passed.
Yes, yes, yes. No, that was not there.
This is our case.
2018 was not there.
That's why, my lord, I am making a humble submission.
No, you have a better case then if it was not there.
Yes.
No, I am not saying it was there. It
No,
was
no.
not there. It was not there.
Page
Not
30,
that-
publication date of publication is December 18, 2018.
Yes.
And the date of that notification is also 18 December 2018. Division bench order, we are repeatedly asking you that.
Yes.
25th of September 2018.
Yes, yes,
So,
I am coming.
division bench, when you come, before you come, we'll come. 2018, the direction was in terms of 2013.
Yes.
On that day, 2018 was not there. So you mean to say that by virtue of this 2018, whenever that came in,
Yes.
unless that is challenged, that will be the governing provision.
No, my lord,
This was my
in a slightly different way, my lord,
Yes.
making in another angle, I kindly look at.
Yes.
My lord, I only make my humble submission regarding whether there is any specific order in the nature of binding upon the
Division
state-
bench.
Yes, division bench.
Absolutely. Why not?
I with with most respect to my lord, with most humility, but I am saying there is no mandamus regarding you have to give preference to the self-help group while
No.
no,
You
my
are-
lord, kindly I am reading as a whole. I am reading. My lord, kindly see. Kindly come to
Page 87, please.
no, my lord, finally come to
No,
page
there is no as a whole. We'll see the direction first.
direction.
As a whole is whatever were the observations of the court. What is the operative portion? Let us come to that.
Let us come. Well, operative part is
Page
not, it's
87.
not, no, it starts not there. It starts with some kindly come to. Well, in the instance case, 85, page 85.
In the instant case, according to you, is a direction, the operative portion.
No, my lord. It is.
What is
in
your
the
idea of an operative portion?
My
We
lord,
don't
this
know.
is the ratio, my lord, I am saying. My lord, maybe I am
We
wrong.
don't want to see the ratio. We want to see the direction.
It is not. My lord, kindly see. Give me just 5 minutes time. If I do not, my lord.
Mr. Sengupta, first you will do what the court is asking you.
Yes.
Let us come to the direction of the division bench.
Yes, but that is as per 2013, my lord. It's okay.
Page 87.
Page 87.
Read the
As
last
per
paragraph. Last paragraph.
2013 control order. There is
Read
a
the entire sentence as a whole. In view of page 8. line.
It appears that the same had been done.
হতে পারে না নাকি?
Well, last para, in view of the aforesaid facts and circumstances.
এতদিন seniors কে নেই, AGP নাকি?
Well, in
What is
view
your
of-
designation, Mr.
No,
Shenugupta?
no,
AGP?
Well, in view of
AGP?
no, my lord. In view
AGP?
of the, my lord, in view of the
You are also AGP?
my lord,
No, we are asking you. This is not a question of law, a question of fact.
No.
AGP or
No, well, I am not an advocate. My lord, in view of the aforesaid facts, I know, my lord, in view of the aforesaid facts and impugned order, the learned trial judge is set aside. Advertisement and the vacancy notice published by the state 13/025 are also set aside. Then it is not readable. The appropriate authority or state government is directed to initiate fresh issuance of vacancy.
we are reading it for you.
Filling up.
It's clear in our copy. The appropriate authority of the state government is directed to initiate steps for issuance of fresh advertisement for filling up the vacancy of Jamtolahat Mouja, Kultoli PS, in accordance with the provisions of the West Bengal Public Distribution System Maintenance and Control Order 2013.
Yes.
The advertisement and vacancy notice shall be given wide publicity in accordance with the provisions of Control Order of 2013.
Yes.
Control Order of 2013 contains the priority to women.
My lord, maybe I am wrong. My lord, again at the cost of repetition.
Maybe the no question of maybe is there.
My lord, kindly see.
Where do you
in
get the maybe from?
In the
You are absolutely
no,
wrong.
my lord, in the aforesaid facts and circumstances means I have to read the judges, the consideration which was taken by the honorable division bench as a whole. I am only pointing out, my lord, two paragraphs.
2003 control order not amended on that day. So
Only question involved here is whether that division bench order is binding to the extent that 2013 control order has to be complied with.
Yes.
control order.
If we construe that to be
It was control order. Was
whether
on that
2013
day.
no, whether this direction means that 2013 control order because it's in the division bench, or if some subsequent amendment is the control order is there, that will prevail. This is the only scope.
That is the
The day division bench passed an order,
Yes.
amendment was not there. Court said
Right.
that
Thereafter the amendment came, the effect of that.
to comply 2013 control order.
So now if after that new notification, if you issue a vacancy notice, whether it has to be in terms of the new amended or by virtue of the division bench,
This is the only point one has to consider.
only point to be considered.
Second,
Why should you go into the observations of the division bench and the on the
because they are
wastage of
saying that this is the judgment on the basis of which honorable single judge. has
we'll look into the direction of the judgment, not the,
So,
the
my lord,
observation.
just give me.
We don't. We are not we are not the appellate court over the division bench. We don't want to see the reasons.
I will show by affidavit ballot and ballot. I will finish that. Affidavit.
What affidavit? First, we grant
use
stay,
that-
then we'll
No,
file
I
affidavit.
use that when I restated everything. In my affidavit, in the affidavit,
No question of affidavit is required.
I will show my lord only two paragraphs. After it, my lord.
Whatever Mr. Sengupta papers are there, if you don't want to add papers, we won't direct you affidavits at all.
affidavit filed with the court.
Before the court below, that's why.
Acha, will come. Yes. Sorry. Yes. Yes, Mr.
Sorry.
Shanmugh.
My lord, I'm sorry, my lord.
You're going to place
Yes,
some
no, my lord. Always, I want to give reply so far. My lord, queries is concerned first. My lord, then I will come back to my lord.
Yes.
Yes, my lord. Is this in the facts and circumstances of this order? My lord already made an observation. Mr. Sengupta come to first. It is clear that 2013 control order has to be applied on the
as per the division
as
bench.
per the division bench, honorable division bench order 2013 act applied regarding further notification regarding vacancy of the said location. So, my lord, 2013 act applicability of the 2013 act, and in terms of the honorable division bench order, is the judicial ratio says that 2013 act includes amendment and whatever is to be taken at the point of time of making advertisement. Whatever law was subsisting at that point of time of vacancy, after passing of there is a fresh vacancy, in terms of the honorable division bench order, whatever law is there, that will prevail. That is my reading. And my lord, apart from that, that the honorable single judge passed an order on the premises that the division bench order is binding. You have to, my lord, there is no question of any further amendment, any amendment. It is not applicable because division bench has passed an order directing the state to take into account of the preference given to the self-help group or other women self-help group, whatever it might. But my lord, my reading, subject to my lord's reading, my lord, my reading says division bench, while the lease was not that, lease was only concerned with the particular person who was the petitioner therein, appellant therein, appellant state and the petitioner respondent therein in the appeal, because his lease was to the extent that right has been accrued and the vacancy notice is not applicable because I have to get that one. Division bench said no. 2013 Act has, because the right accrued, that was prior to 2013, that is 2003 control order. So, honorable division bench says there was a lot of change in the controls order. So, and the right has not been accrued because state has not approved at that point of time before promulgation of 2013 control order. So that's why your right has not been accrued. So there is no cause of fresh notification, fresh vacancy. And fresh vacancy is to be made in terms of 2013 control order. And 2013 control order means that whatever law is applicable at the time of present vacancy. This is my humble submission. And my lord, kindly consider, apart from that, the division bench order, my lord, kindly come to page 86 only. I am, my lord, maybe 86. I am wrong, my lord, but my lord.
No, you are right.
I am
86. 86?
86. Page 86, my lord. Last, page 86. 86, 86 of the appeal filed by the Kultuli. Well, at the division bench order, page 86, got it, my lord.
It is not in dispute. Read it.
It is not. It is not in dispute, in question, could not be filled up due to continuous litigation for the last 15 years or more. When the vacancy was declared initially in the year 2003, that I have already submitted, 2003 Controller 2013 was in force. The Controller 2013 came into effect on August, from 18th August 2013. As per clause 26(2) of the Controller, if the district administration feels it to declare a new vacancy, vacancy shall be declared with the approval of the department. Such vacancy has to be widely published in the official note board, official gazette, notification, advertisement in local as well as widely circulated daily newspaper. As per 2013 Controller, there is a provision for giving preference. They are harping on the pen, and the Honorable Singhal is also harping on the same point, that preference should be there in the future vacancy notice. That is, there is no order, mandatory order passed by the Honorable Division. No, before making vacancy, you have to give preference, whatever may be the law before vacancy. My lord, kindly see, as per 2013 control law, there is a provision for giving preference to self-help groups, especially women. So my lord got it. Especially women self-help
You're
group.
continuously reading. Why are you saying repeatedly got it, got it?
For inclusion to the provisions giving preference to content groups to implies that the zone of consideration of eligible candidate gets widened. And the state gets an opportunity to select the best possible candidates for the purpose of the. Accordingly, decision of the state government to invite facial for candidates were not seen to be arbitrary and unreasonable. The only pinching point is change. I am not on that. This is the ratio. That means, my lord, kindly consider best possible scenario. My lord, kindly see to select best possible scenario. Now, I could have understood the vacancy notice, which is under challenge here, that is there in the amendment portion, amended provision, it has come into effect 2018, something like that. There is a provision also, self-help group, Mahasangho, everything, they can all participate, but preference was lifted. But that means widen. The Honorable Division Bench order speaks of widening, that is not limited. It is there in the future vacancy notice.
Yes.
And my lord, kindly consider the judgment. And my lord, I do not, my lord, kindly see page 121, only 121. That my lord knows that dealer is tagged with the consumer, distributor is tagged with the dealers. That is the difference. And vis-a-vis wholesaler. My lord, wholesaler means sub-district. My lord knows that. My lord, last point. My lord, this is regarding 50 lakhs. My lord, 1, 2. Applicants of distributor, because he is the distributor.
Right.
So 50
yes.
lakhs. Now, my lord, this is important. This order shall also be applicable while processing vacancy for which inquiries may be ongoing or complete but have not been approved by the department for the engagement of the soil. This is very vital. So I could have understood that is by this time that was approved by the department. That I mean to say, my lord, the preference. So, my lord, because the admitted fact, nothing was approved. So, for the self-help gives is concerned, obeying or whatever it might be. My lord, now, my lord, he did not challenge this amendment and admitted the vacancy notice came after the promulgation of this amendment. He could have challenged. He did not challenge. Now, my lord, kindly see the honorable courts, the honorable single judge order. Kindly see. And my lord, yes, my lord, in after that, my lord, kindly see, it is very important, page 164. It is very important. 164. It is 18 December 2020. My lord, got it? It is notification.
Yes.
18 December 2020, my lord, got it? First. Now, kindly see last order. That 25 lakhs, 50 to 25 lakhs, my lord, kindly, it was reduced. My lord, got it? Two. The honorable single judge has taken into account, my lord, but unfortunately, but I cannot say that word unfortunately, but my lord, she misconstrued the law, because next line is very important. This order shall not be applicable to the vacancy, distributor, wholesaler, FPS dealer, which has been notified by the licensing authority on or before publication of the notification in the official gazette.
Learned single judge order was not on this premise. It did not say that 25 lakh. Rather, it was noted.
Noted. But
noted that the amendment subsequent, but that is not applicable. That was noted. There is no dispute on this.
Then, my lord,
that you have seen.
Yes. Then, my lord, kindly see the last, my lord, the observation of the honorable single judge.
Yes.
Well, kindly see. I am starting page 11, paragraph 11, 173. Well, I am not on that only relevant part.
Ajay, where is this vacancy notification dated 17/7/2019? That is the page 35, 34, 35, that one. Yes. Paragraph 11, Mr. Sengupta,
Paragraph?
you are placing judgment?
No, I am placing, my lord, paragraph 11 of impugned order
Just you're asking that.
173. My lord, kindly see. While the observation, this is very relevant, what the premises precinct the Honorable Single Judge has proceeded with, that is wrong. While the observation of the division bench in relation to women's self-rule is relevant, the contention of the state as well as the added respondent of the amended controller 20 also cannot be ignored. Kindly see. She admitted, cannot be ignored.
You are not ignored but
Yes.
overruled.
According to the state and added the preference to self-help clause 26 was amended on 18/12/2018 and was done prior to vacancy notice of 17/7/2019. The relevant paragraphs of amended provision, which is part of the affidavit of state respondent, that is mine, shows that Jonah was widened to not only include self-help groups but also registered cooperative societies, further widened. Why scope has now become further widened because
Make your commentaries,
yes,
please.
sorry. In individuals and group of individuals, admittedly, the petitioner did not challenge the amendment to the made to the 20th controller. It is therefore arguable whether the petitioner can now question the dilution of preference given to the women run self-help group after publication of the impugned vacancy notice. Now, my lord, kindly see. Further, my lord, kindly see. This is the, my lord, I am not. It is not. My lord, Vidyadhati, my lord, I have referred something. Petitioner also referred something. My lord, now, my page 19, 177. Paragraph 19, 177. That is the conclusion. Page 177.
No, how was the other grievance dealt with? 50 lakh and all?
Yes.
That was the main grievance,
That is
clause 5.
Paragraph 19, kindly.
What was done to that? That was upheld.
After considering the case, my lord, I am reading. 177. Page, paragraph 19. After considering case made out by the parties, the only conclusion, my lord, kindly see, which is reasonable in the present fact is the parties must comply with the division bench order 2018. This is the crux of the case. And a part of this compliance is in the form of impugned vacancy notification dated 77. But a part of that is the spot. Not the end. Division bench order is clear. Honorable division bench says you declaring the vacancy, you just follow the 2013 control order. Nothing more, nothing less. And Malak, kindly see. It is, state must, however, ensure uniformity in all the notification advertised by in the MRDC across the state. It is of utmost importance that the conditions where specified particularly are kept uniform throughout the state, including the financial services. State has already reduced, already reduced 50 lakhs to 25 lakhs by the order dated 2020. And I have shown that because 2020 is not applicable where the petition is pending. Kindly see. And it, the state government order has, however, not been made applicable to the vacancy which are notified on or before its publication. Yes, I have already shown that. Since the court has found a few unexplained lacuna in the impugned vacancy notice 17/77, including in respect discrepancy with the other vacancy notification throughout the state, state government is direct to modify the impugned vacancy notice Jam Talahat in conformity with the direction of the made by the division bench. And also in terms of the relevant control order passed. That means 25 lakhs you have to take into consideration and preference to be given. I think, in my limited knowledge, this is not permissible under the law. And the notification.
We can understand that.
Yes, fine.
Yes.
This notification should be made in line with the reduced financial solvency limit. Kindly see how it can be made. And the other notice across where the margin has been halved. Zone of consideration will be in.
You had argued before that court also.
That's why, I have kindly see. My statement has been recorded that this notification is 2020 that are reduced. that 50 lakhs has been reduced. This is not applicable to his case. In spite of that, the Honorable Judge, on what basis, I do not know, my lord, I cannot explain. My lord, there should be a law, and rule of law, my lord, must be based on, my lord, the statute. And my lord, this is, my lord, kindly is one under what I just put that question to my side. Under what provision of law, zone of consideration will be in accordance with the latest notification. The court is not inclined to cancel the, since it is undisputed, the vacancy would not be filled up for more than 20 years. Such and such appointment or such and such. Jamtola, my lord,
So the direction given to you was to modify the vacancy notification in terms of the division bench direction, one, and secondly, in terms of the relevant government orders notifications, which the court presumed to be in terms of the directions of the division bench. But at the end of the day, in terms of the relevant government order notification, which you say is the 2018 notification, according to you.
Yes, that is a fact. Yes, admitted fact.
And also in terms of the
2020, that is not applicable.
No, 2020 is not applicable.
No, that is
No, it has been. That is an observation. The modification should be made in that. There is a bit of contradiction in para 20.
Yes, yes.
Modification should be made in line with the reduced financial solvency limit, but that has not been given effect to. But the zone of consideration, including for self-help groups, will be in accordance with the latest notifications, which was published pursuant in the division bench judgment, which the learned single judge presumes in the previous paragraphs.
Yes, yes.
Must be in conformity with the,
Yes, that
which are presumed to be in line with the.
That is not the.
But even if those are not in line with, those have to be as per the direction, those have to be complied with.
Only direction to, before making advertisement or vacancy, whatever it.
But these two, you say, will be then contradictory. Because in terms of the division bench direction and the applicable vacancy notifications are mutually exclusive.
There is no challenge to that. I mean,
Those are there. Those
That
have not
is-
been dealt with.
Yes,
also.
that is my subject. That's my
Very good. Yes, Mr. Shara.
But I'm sorry, my lord, because I, as a tendency,
Accepted,
my lord,
accepted,
don't
accepted.
accept. My lord must
We have accepted.
because yes, no, my lord,
We have accepted before you tender.
otherwise, my lord, because I have.
Mr. Shara.
Before going to the documents, just 5 minutes, the history of the case. Because
No, not again.
this has relevancy. So for the 2003 control order and 2013 control order. Just I'm not.
No, please.
On 21st June 2011, vacancy for MR distributor at Jamtalhat, Pulhati has been notified.
Can you please repeat the date once?
21st of June 2011.
Yes.
Under control order 2003. Kindly take note of.
List of dates.
Yeah,
No. That has not been mentioned. Your Lordship, need not go through this. Your Lordship, kindly give me 5 minutes time. 21st June 2011, vacancy has been notified. Kindly take note under 2003 control order, where there was no provision for giving preference to self-help groups or especially women-run self-help groups in 2003 control order. One Borun Ghosh and my learned friends clients applied for, along with other 7 candidates, total 9. Inquiry has been conducted. It was found Borun Ghosh is the fittest candidate. So far, their candidature is Kultuli. Proposed shop-come go down is not in the advertised location. Their go down was in BDO office. Borun Ghosh name has been
was in BDO office.
BDO office, nearby BDO office. So I shall show from the order.
May I take it?
Borun Ghosh name has been recommended by the district controller and forwarded to the director. Director also forwarded the name to the secretariat for final approval from the secretariat. But the principal secretary refused to accept the proposal only on the ground that in the meantime 2013 control order came into force by giving preference to the self-help groups, especially women and self-help groups. The only reason for cancellation of the recommendation. During pendency of that 2011 vacancy notice, 2003 control order came into force on 8 August 2013. Only sole ground that new control order came, a group has been given preference, they should not be deprived. Recommendation has been rejected. And direction has been given upon the district controller to declare fresh vacancy in terms of 2013 control order, which provides preference to the self-help group, especially women and self-help groups. Vacancy has been notified. Varun Ghosh challenged both the orders, rejection by the secretary and fresh vacancy under 2013 control order. He won before the learned single bench. The learned single bench, Justice Topobroto Chakraborty, quashed and set aside the order of the principal secretary and stayed the vacancy notice issued under 2013 contract till fresh decision is taken. Please take note of there is no revenue is involved. State preferred an appeal. Why I am showing, I shall show to your lordship. My client also preferred an appeal against the order passed by Justice Topobroto Chakraborty. Kindly take note of my lord, page 8, the judgment, page 82. One paragraph I shall read that has been read before your lordship. Kindly take note of the date. It starts from page. Just giving the page 62. Kindly take note of the date.
Page 82.
62.
62 is the beginning of the judge.
Kindly see the date. 25th September.
Yes, we have seen that. Yes, that was relevant because of
now
the
if you
next
kindly allow me 1 second. Page 86. 2 paragraphs.
Yes.
Page 86. What is the order? It is not in dispute that the vacancy in question could not be filled up due to continuous litigation for the last 15 years or more. When the vacancy was declared initially in the year 2003, the Control Order 2003 was in force. The Control Order 2013 came into effect from 8th August 2013. As per clause 26, Roman 2 of the new Control Order, if the administration feels necessary to declare a new vacancy, the vacancy shall be declared with the approval of the department. Such vacancy has to be widely published in the official notice board, official gazette notification, advertisement in local as well as widely circulated. As per the 2013, kindly take note of. There is a provision for giving preference to the self-help group, especially women self-help group. In view of the inclusion of the provisions, kindly take note. In view of the inclusion of the provision for giving preference to certain groups implies that the non-condition of the eligible candidate gets widened and the state gets an opportunity to select the best possible candidate for the purpose of distribution. Well, pausing for a moment. So division bench only interfered with the order of the learned single judge since 2013 Control Order came into force, which was the reason to reject the recommendation by the secretary also. Accordingly, the decision of the state government to invite applications for grant of distributorship does not seem to be arbitrary or unreasonable. The only pinching point is the issue of change of location of the distributor. Kindly take note of. The vacancy at Jamtalhat could not be filled up for a considerable period of time. Accordingly, the need to fill up the vacancy in very clear. Without any politician of reasoning to shift the location of distribution, the action of the state in shifting the location smacks of malafide bias. It appears that the same had been done with the sole intention to favor a candidate, did not have the go down within the activity area. Such action on the part of the soil. So, kind person for a moment. I have submitted to your lordship. So, for my learned friend is concerned, their proposed go down was not situated on the advertised location. Thought that the second vacancy has been issued by the district controller in post office area so that they can fulfill. That has been taken note of by the learned single judge, Topobroto Chakraborty, also division bench. Why I am saying so? Well, this is not a revenue matter, a state has preferred appeal. Kindly take note of. Kindly take note of. Next paragraph. Now, in view of the aforesaid facts, the interim order of the learned trial judge is set aside. The advertisement and the vacancy notice published by the state on 13 July 2015 are also set aside. The appropriate authority of the state government is directed to initiate steps for issuance of fresh advertisement for filling up the vacancy of Jamtalhat Mauja, Pultuli in accordance with the provisions of the West Bengal Public Distribution System Maintenance and Control. This is mandate. This is mandate, not the observation. The advertisement and vacancy notice shall be given wide publicity according with the provisions of the Control Order 2013. Matt so is disposed of accordingly. So direction of the division bench is to notify the vacancy in terms of 2013 Control Order. Now, your lordship, kindly come to page 60. That is not required. Kindly come to page 30. Page 30. Kindly see the date. Appeal has been disposed of on 25th of September 2018. And
page 13.
13.
13 years.
when this amendment has been taken place.
Yes.
18 December 2018.
Yes.
And division bench judgment 25 September. So, my lord, can they take advantage of this notification? The division bench says you issue the notification in terms of 2013 control order, which includes preference to the self-help group, especially women and self-help group. They waited. Rather, they modified the control order. What will be the consideration? This amendment, division bench judgment. Admittedly, they didn't take any steps for declaration of vacancy in terms of the division bench order. Rather, they have amended the control order, excluding the self-help group.
Mr. Chahada, why shouldn't the same logic applied by the division bench apply to this case?
I shall show. So far 50 lines.
You understand?
So far 50
No,
lines.
not that. The logic of the division bench, as per your submission, if you understood you correctly, is that 2003 was the premise of the previous vacancy notification, 2013 came in. That's why division bench said that since 2013 has come in, that should prevail and issue fresh notification. Why shouldn't the same logic be applicable just as between 2003 2013? Now, in your case, between 2013 and 2018, because since in the meantime 2018 has come in, now it has to be in terms of the new notification. That was the logic of the division bench order vis-a-vis the previous change.
Kindly read the observation and the mandate of the division bench. Division bench says that the secretary rejected the application on the ground.
Yes.
Self-help group. And
that was upheld.
Upheld and observed that since there is a provision for giving preference, I am passing this order.
But the premise was giving preference was incidentally included in 2013.
Yes.
But the ground was that since 2013 has now come in, 2003 cannot prevail.
Yes.
Self-help group, women self-help group cannot independently be a ground. That was incidentally there in 2013. The ground of the division bench was not women self-help group.
Absolutely, sir. My understanding,
Women self-help group.
Because
This was an observation.
No,
Women
kindly take
self-help.
note of.
That is not the
Kindly take note of
premise.
Page 86. Page 86.
86, 87.
Yes.
Yes. Rather, it was argued that, that it has been widened.
5 lines. As per the 2013, 3 lines. As per the 2013.
Which page?
Page 187.
87, yes.
From top, cut line.
As per 2013 control order, yes.
There is a provision for giving preference to self-help groups. Special women self-help groups, in view of the inclusion of the provision for giving preference to certain groups, it implies that the sum of the consideration of eligible candidate get appointed and the state government and opportunities for the best possible. Accordingly, the decision of the state government to invite favorably is accepted. What is the decision of the state government? Cancel the vacancy, declare fresh vacancy where...
That was the reason for accepting. The court said that accordingly, the decision of the state government to invite fresh applications, not arbitrary or unreasonable. Why? Because by virtue of this change, it had been made wider. But the previous page, 86, second paragraph, it stated clearly by way of reasons. In the present case, though the reasons are not specifically mentioned in the fresh advertisement, apparently the authorities decided to invite fresh applications, keeping in mind the change in the law which had taken effect during the pendency of the selection process. That is 2003 to 2015, meaning thereby the 2013. Therefore, the change of law was the ground that was upheld by the division bench.
What was the impugned in the previous proceedings? The order of the secretary. What was the order?
You have not even challenged 2018 control.
Follow on the basis of the division bench judgment. Because division, well, this is subsequent. Can they take advantage of the subsequent?
Division bench judgment was on the basis of the control order then prevailing.
Well, then,
what is the effect of a law which comes subsequently? If I pass a direction that as per the prevalent law, please issue the advertisements.
Well,
then a new law comes in. Doesn't that become academic?
According.
What accordingly?
Page 87.
Yes.
After 7 lines. According to the decision of the state government to invite upper 7-8 lines. Why?
Accordingly, read the previous line before accordingly. In view of the inclusion?
Yes. 2013 control order.
It implies that this is on the ground why it is not arbitrary. A challenge was preferred that this new vacancy notification is arbitrary. Court says no, not arbitrary because it was expensive, made expensive.
The previous vacancy notice has been cancelled on the sole ground that 2013 control order came into force.
Yes.
With specific reference to the self-help group, women and self-help group.
This was one of the grounds by the division bench.
No.
Division bench did not say 2013 and mention that special reference has to be given to special women's self-help groups. If that was so, then we would understand.
Two part of the order.
Just blanket 2013 order in terms.
Two part of the order. First,
Previous portion is not a direction,
first
not an operative portion.
accepting the order passed into order issued by the secretary. Why I am accepting, why I am rejecting the writ petition, order passed in the writ petition. The learned single judge held, I have annexed single judge held that this decision to quash the interim order is maintainable because 2013 control order cannot be considered. That was the judgment of the single bench. Division bench came to a conclusion, no, widened possibility to give license to the best candidate.
The single judge reasoning, Mr. Shahara, with due respect, the single judge was as utterly confused as us.
So far, I am not saying.
Page 10, the state government order was, however, not meant since the court has found the
not on that order. I am the order passed by Justice Chakraborty. Justice Chakraborty.
Yeah, understood. But since the court has found, because this has to be German, since the court has found a few unexplained lacunae in the impugned vacancy notice dated such and such, including in respect of discrepancies with other vacancy notifications throughout the state, which were not the subject matter of your challenge also.
If your lordship kindly accept the views that the division bench passed an order, thereafter amendment has been taken place.
And court says,
no,
court says also in terms of the relevant government order notification issued by the state government 2018, that is the 2018, which was presumed to be in line with the directions of the division bench. It was not in line with the division bench. Then what should be followed? The learned single judge says, yes, extant regulations, which is presumed to be in line with the division bench. If it is not.
Before that, there are facts also. If your lordship accept the views that state subsequently changed the mode of selection. Why?
Absolutely changed. You could have independently challenged 2018 notification. You would have a better case.
It will be affected in respect of all conditions. Other conditions also?
Yes.
Then your lordship kindly come.
As per 2018 notification, it has to be as per 2018 notification.
Kindly come to page 13. I have shown to your lordship. Now your lordship kindly come to page 37.
Yes.
Kindly see the date. This is 16 January 2019. What is the condition? Second paragraph. This is subsequent to advertisement. Subsequent to relaxation. I start with withdrawal of the relaxation. Second paragraph.
But you had not challenged this.
No. All vacancies withdrawn. I shall show to your lordship.
You have challenged page 13, 34.
In other Manbajar, a vacancy has been notified. Subsequent to amendment. Kindly see the date. 16 January 2019.
Yes.
This is subsequent to.
Yes.
Kindly second paragraph. While selecting suitable candidate for granting distributorship license under the West Bengal Public Control Order 2013, preference may be given to the self-help groups, especially women and self-help. Why? Why? It is for
Don't
all.
they have that discussion?
Yes, no.
This was for similar type of work.
Absolutely.
Cancel হয়ে গেছে
যা সেটা দেখাবো সব দেখাবো সব কেন ক্যান্সেল হচ্ছে দেখাচ্ছি
cancel this is
Yes.
not in
why
This has been cancelled.
that's my case why cancel
Why cancel?
cancel
the vacancy of distributorship third line there is no dispute same vacancy kindly come to next page 50 lakhs is there the 1.5 English 5 page 38 second paragraph 5 my lord
Yes.
50 lakhs precedent 1 year. Then kindly turn to next page. This has not been placed before your lordship. This is 1st August 2007, 7th August 2009.
Yes.
Kindly read, my lord. Paper book page. Or I am reading. Second paragraph. This is issued by the government. And whereas the constant district order food and suppliers have subsequently either not notified those vacancies in the official gazette, notified but no application has been received against those vacancies, notified but the validity of those applications expired due to a eclipse of time, for non-possessing of the same within the specified period mentioned in the Constitution. And whereas, kindly take note, besides above, this means the department has been made to contest civil court cases in the Honorable High Court at Calcutta against the aforesaid vacancies on the ground of applicability of the clauses, particularly relating to the restrictive clause of financial solvency of rupees 50 lakh for last 1 year from the date of application and generally on the norms of go down number of parts also. And whereas the considering the above facts and circumstances, the state government has considered it expedient and necessary to cancel the notifications issued by the district controllers against the below mentioned vacancies in Procedural. Now, therefore, the government, the Department of Food and Supplies directs concerned district controllers to cancel the vacancy notified transfer. All vacancy, all over cancelled, 50 lakhs condition. Except this Jamtala. Except this Jamtala. If subsequent notification is taken note of, this notification should have been taken note of. All vacancies in all over West Bengal, it was found condition number 50 lakhs for preceding last one is not maintainable. Kindly take note of page 29.
Page 30, 40.
No, page 29. 40, next page. Kindly come. Table number 2. South 24 Mouja Ganeshpur, not Jamtala. Even on that district, same vacancy, same period, withdrawn. It is not discriminatory. State will not appeal against the order of Justice Chakraborty. Again, I am repeating, this is not a revenue matter. In all of our West Bengal, all vacancies withdrawn. For unreasonable clause number 5, which suggests 50 lakhs for 1 year. Except Jamtala. Jamtala taking advantage of a subsequent notification without giving preference, fresh vacancy, not withdrawn. Now kindly come to my lord.
So that is why your writ petition challenges clause 5.
Yes.
Because that was the premise of the cancellation of the other.
Specific prayer, specific grounds.
So you say that if clause 5 is taken out or in terms of something else, then or this should entirely be set aside then also. That's your alternative.
And today scenario has been changed. I shall show you a lot. Then I will also kindly come to.
But the women's self-help group then becomes irrelevant. Because 2018, we cannot in the same breath say 2018 has to be
one line answer.
Given
2024 controller came into force by giving preference again.
Please repeat. Yes.
2024 controller under TPDS came into force.
2024.
Yes.
Where is that?
I shall show everything. Nothing has been placed. Kindly come to page 164.
No, 2024 was before this. Yes.
Kindly come to page 164.
No, 2024 this is after London single judge's order.
Yes, sir. Absolutely. Today, what is the control order? Today, there is no public distribution system control order.
Inter-court appeal is not exactly like section 96.
After coming into force National Food Security Act, entire provisions has been changed. I shall show.
So maybe, but on the date of we have to see the veracity of the on the date of that. That was not available before the learners.
Page 164.
162. So every other notification, every district was
withdrawn and
except this.
Absolutely, Shop has been withdrawn except Jamtala. And all those vacancies has been declared subsequently with fresh condition of 25 lakhs only on the date of application. And subsequently, that has also been withdrawn.
Yes, because if the notifications are withdrawn, then it has to be a fresh notification, and then 25 lakh would come in.
Peculiar thing, only retaining one vacancy in all of our West Bengal with amended clause. That's not fair also. Right. Specific case, back up 2, 3, 4, 5, 6, 7 in our petition. I shall show. Kindly come to page 164.
162.
164.
4. Yes.
18 December 2020. Kindly take note of my lord. Serial number 1. Application for distributorship. There must be.
No, this you have seen 25 lakh. The last rider is shall not be applicable vacancies which has been notified by the licensing authority on or before. So you say by virtue of this all have been taken. So then it has to be under this This or if now, then probably 2020.
Fully they retain the conditions. In all other vacancies withdrawn. After this was issued, fresh vacancies has been declared. Again, that has been withdrawn. Kindly take note of it.
After 2024?
Yes, no, not 24. Just after this. I shall show to you. Just I'm showing you. It has again been changed. 25 lakhs. Kindly take note of this.
Your bone of contention is 25 lakh
Yes.
and not women's self-help group.
That is also one of the count. That is also one of the count. Kindly take note of this one. Now it is only on the date of application.
You can give a copy to them also. Sir.
Mr. Amrar is there. There are hundreds of copies.
Don't give a copy to Mr. Sengupta. He's the state. He should know. Everyone else should get a copy.
Kindly take note of it.
No, but he has to know what is there.
He knows everything. Clause number 2. Must have a working capital. 25.
That is his perception or general perception?
Maybe or Mr. Amrar also. Kindly take note of it. Applicants for distributorship wholesaler must have a working.
What is it? 2022? Another?
Yes, another. Only on the date of application. First 50 lakhs for 1 year. Second 25 lakhs for 1 year. Now 25 lakh only on the date of application. I am ready to submit my application.
Obviously you are.
Last 1 year I have no money. But 25 lakhs I can arrange on the date of application. My specific case, if this condition is introduced for all, it should be introduced in Jamtalhat also.
This is still in force.
Still in force. This is still in force.
No, but you said that there has been a fresh cancellation. Where is the cancellation of the others?
All the vacancies cancelled.
That was cancelled by virtue of this.
Page 39. All over West Bengal, all vacancies withdrawn.
Yes.
And all those vacancies has been notified subsequent to issuance of this notification. That is 25 lakh only on the.
Oh.
Yes.
Acha. This after this cancellation, the new
notification 25 lakh for last 1 year. No vacancy. Vacancies have been declared only 20
after 22.
In this case, if the vacancies is declared today, in following this circular, I am ready to participate.
You said 2024, something else has come in?
Yes, I shall show you.
What is that?
That's some kind. Now, your lordship, kindly see. After that, page my lord,
but 2024 is after single judge's order. So we can, as per your argument, accept this.
Possibly, no, possibly your lordship have to accept because I shall show you just page 104.
104.
The application of my learned friend's client. Because they are not party in the petition, subsequently they file an application for addition of party, and I have could not taken this point in my petition because they are not party initial. In my opposition or reply, I have taken all these points. Kindly turn to page 104. Full residential address of the applicant, not applicable. Permanent address of the applicant, not applicable. Now turn the page. Thus, any member of the applicant's family protest for a distributorship license of so and so, not applicable. This company has 3 distributorship. This company has 3 distributorship.
Which item?
So last 20.
Acha. Acha.
Thus, any member of the applicant's family possesses APS or distributorship license under public distribution system, not applicable.
No, this is a company. How can a company have a family?
I'm coming to that. Address should be then the district.
No, applicant's family. This is not a sister concern concept.
One of the family member who is also.
It's a company, juristic entity. How can it have a family?
Director.
It may have sister concerns and all.
Now the company has been washed out. For this reason.
That is different.
There is no pleading.
But this is really not applicable because it's a.
All right.
Whatever my landed friend is
This is probably going too far. Because Mr. Shah have probably not before the that's all.
Even the declaration of vacancy.
Is jumping and jumping. He has not preferred any appeal.
No, there is no.
State has accepted the position. Mr. Sengupta may not accept.
No, state has preferred the appeal.
No.
State
cross objection.
State has no.
By
jumping.
Jumping.
He has accepted the position.
Why is so apprehensive?
Because you are jumping.
No, my lord, because I have a good case. My lord, because
That doesn't make any reason to jump.
my lord, there is no pleading that regarding that whatever he has submitted right now.
Let him finish.
Yes.
But he has accepted the position. So far, the order of the learned single judge is concerned. Without
Even if you speak softly, he will be able to hear. So you argue in your own way. He's sitting just beside you. So you have that, you run that risk always.
now, my lord, the 2024 control order.
Mr. Sharat, right, till now we have found your best point to be, you have 3 points apparently. One is self-help group observation. Second is 2013 direction. It has to be strictly in terms of that. If all fails, 2018, this violates Article 14. And there is reference twice in the learned single judge's order. Mr. Agarwal, you want to go some? Yes, yes. In the learned single judge's order that there has been a violation of Article 14 without saying Article 14, but all other districts in parity with the others.
Half the way, amount that has also been observed by us.
Half the amount has no, but the learned single judge says that's a contradictory finding because of your contradictory arguments. You, not only you, Mr. Sengupta contributed the most. It's very apparent.
Whatever may be the learned single judge order.
Anyway,
Then
but
your lordship
therefore,
kindly-
yes. So 25 would be applicable if it is now done.
Now, my lord,
If
now-
we allow your, if you dismiss their appeal, very well.
Now, today,
So we can also dismiss their appeal by supplying separate reasons also to the learned.
that is
Because this
that
is something which has not been spelled out.
That's always permissible. If an
Yes,
order
yes.
is upheld by giving supplement direction, that is not. Well, now, why I am saying about 2024 control order.
Yes.
So first round, division bench came to a conclusion 2013 control order with special condition of the right. Now, National Food Security Act came into force in 2013, changing the entire concept of public.
These are not even argued before the learned single
No,
judge.
why I'm saying it will be impractical order. Just give me 5 minutes. APL ration cards, BPL ration cards, all goes. Public distribution system goes. Now targeted public distribution system, only one type of card, household, eligible household. And 24, relying on National Food Security Act, 2015 Central Control Order has been promulgated, and following the same, 1st August 2024 Control Order 2024 targeted public distribution system control order came into force.
That's a new
That's
argument.
why I'm saying so. Today, if
we have to relegate it to the
area of go down, storage capacity, everything has gone. Just one paragraph of 2024 control order I'm placing before lordship. Just one paragraph.
These were
absolutely subsequent event. Absolutely subsequent event. But the order will be not workable. How they will issue the license? Under 2013 control order or 2024. Unless 2024 vacancy notice is notified, there is no scope for granting license under 2024. 2013 control order has been washed out, redundant, non-existence.
So none of these control orders remain now.
No, only 2024.
Yes, 2024. Even up to 2022, it is no longer there.
Well, just take up this book for a month.
A book.
No, red book.
Red. Lalta. Lalta ফেরত পাঠানো হয়েছিল?
Hand over.
হ্যাঁ আছে লালটা তো
Two books, sir.
লাল নীল দুটো ঠিক এরকমই সাইজ মেরুদণ্ডটা দেখানো ওটা স্পাইন দুটোই আছে দাও
But book page 31, right hand side.
Yes.
X1. Clause X1, page 32.
Clause X1.
Yes, page 32. Who is not able to participate?
No, this is different.
Page.
পাচ্ছেন?
Just first after 3-4 pages. Page 31.
এটা ও আচ্ছা এই 32 আচ্ছা আচ্ছা
May I hand over?
উপরে সামনের দিকে
এই বইটি ও আচ্ছা আচ্ছা আগেরটা আছে
There are 2-3 control
yes yes several paginations
kindly come to
page 32 x1 yes
today whether company can be granted any license. A corporation or company other than the company or corporation under the state government.
these are barred
bar disqualification to get distributorship license. And eligibility criteria 30. Roman 3, 30 Roman 3. Maharashtra self-help groups registered cooperative society having the registered address and so. Today, Marat court should see the order can be given effect to. It can be implemented. Has to take note of the same. Following the
This came into force when?
1st August 2024. Absolutely subsequent to all this. But what order should be workable one. If your lordship directs to consider the application on 2013 controller, they
In terms
have
of
to,
this.
they
Now
have,
it has to be in terms of
yes. And in that case, they are part. They cannot apply even. Why this policy? This company holds 2-3 monopoly. That has been taken note of.
No, this writ petition was yours.
Yes.
This...
My writ petition. Self-help group is permissible. But company is not permissible. They are the company.
No, they have already been given a license.
Yes, in respect of other. This has not been given because this is still pending. In respect of
We are not bothered with their locus standi to apply under this. We are bothered with your plight. Because this was your writ petition. They did not file a writ petition.
But to stop monopoly, state government thought it fit so that why?
We cannot reopen anything which has been acted in their favor.
Shall rely upon only one.
But you are in, if you are entitled to apply, we can direct the government to issue a fresh
50 lakhs discrimination, Article 40. In all over West Bengal, you have withdrawn.
That is the best case.
And subsequently, you have declared the vacancy with the condition 25 lakhs on the date of application.
So if you can sum up your grounds, one is that.
First ground is that I am a self-help group, woman run self-help group, division bench taking note of.
Yes. So division bench, page 86 actually. Page 86 of division bench, woman self-help group.
No,
page
my submission is accepted the order of the secretary, which has been rejected the recommendation of Porun Ghosh on the ground 2013 control order came into force with reference to the self-help group.
Yes.
The division bench accepted the order impugned, which has been quashed by the learned single judge. The reason is that quashing of the order of the learned single judge is
Porun Ghosh, Kultoli, everybody goes then.
Everybody goes. But the condition of accepting the views of the secretary and quash the learned single judge order by the division bench is giving preference to the self-help groups.
After the division bench order, this is the first notification. This impugned, the one you impugned in the writ petition, that was the first vacancy notification. If that goes, then they also go.
Yes.
Then now they are debarred.
That has to go. That has to go. This discrimination cannot be accepted by the division bench. What prompted the state government to withdraw the vacancy of Kultali like all other vacancies? What prompted the state government to declare vacancies only 25 lakh on the date of application in respect of all vacancies in all of our West Bengal?
Wouldn't that be a disproportionate penalty on them? Because as of the date the learned single judge's order was passed, they had a right as a company.
So for company is concerned, I am leaving to your lordship.
No, but we cannot change. If you accept your proposition, we have to set it aside, lock, stock, and you are correct. It will not be workable.
Pass any order.
Can you carve out an exception? You are right. 2024 has come in. We cannot, the court cannot carve out an.
Kindly take note of the division bench judgment. 2003 control order, 2013. Division bench says previous order. The principal laid down. No, everything will go. Fresh vacancy. Today the same situation. Today the same situation.
As on the date the learned single judge was passing order, it was not the same situation. That situation was the same, but then it should be if you.
Situation says
the learned single judge had directed this.
Situation is only one. New control order with specific provisions, separate provisions. Today, no license can be granted to my learned friend's client.
Was any stay order granted in respect of this appeal?
So far, this
operation of the impunity of the learned single judge.
I is getting the application stage.
But I got interim order in my writ petition altogether. So far, my writ petition is concerned. Till the date, Justice.
Achha, these are your ground. First is women self-help group. Second is 2013 control order itself has to be then implemented.
Yes.
And more importantly, this Article 14, this 2022.
Withdrawal of vacancies are over West Bengal except Kultu Jamtala. and declaration of fresh vacancy after coming into force new notification which suggests prescribes only 25 lakhs on the date of application, which I am permissible, which I am accepting.
So, yes, page 39 is that withdrawal, 3940. Very good.
Possibly, if your lordship, just to judgment I shall rely upon before that,
Yes, yes.
conclusion is that even if your lordship was the order of the learned single judge and direct them to proceed on the basis of 2013 control order and grant license, possibly that will be an impractical order.
No, that we can't be doing. If we quash the the learned single judge's order, then we would have to direct otherwise, apart from your other argument, 2018 in terms of 2018. But 2018 has now undergone these changes. 2022 has come in.
That's my
So
case.
then we have to take 2022, and if you take 22, then why not 24?
Absolutely, man. But that will be impractical. Can your lordship direct
Impractical, yes. That
proceed on the basis of 2013, grant license 2013, entire scenario, entire
full setup will go. No, it cannot be. Yes.
rationing system has been changed. Today there is no public distribution system. Today it is targeted public distribution system following the National Food Security Act.
So if we
Consumers have been changed.
then we cannot sustain the single judge's order also on that point.
Absolutely.
But learned single judge does not say 20 any particular given year.
But
Single judge says, let us see what. Yes, we can enumerate that. If we sustain,
material point of time 24 controller
if we sustain the order of the learned single judge, then what happens? Not inclined to cancel the impugned notification since it is undisputed that the vacancy inquiry could not be.
So 2013 controller vacancy remain.
Modification should be made in line with the reduced.
Yes.
No, the
What modification? Up to date modification.
and also in terms of the
Kindly turn to my lord page.
since the ordering since the court has found a few unexplained.
Just one paragraph.
No, 10 first, because since the court has found a few unexplained lacunae in the impugned vacancy, including the state government is directed from here. This is the first direction. Directed to modify the impugned vacancy notification in conformity with the directions passed and observations made. This cannot be sustained.
Kindly come to page 170.
Cannot be sustained.
Page 170. May I read my lord?
And then now the next portion, page 10 itself. 10 itself after 25/9/29 and also in terms of the relevant government order notification issued by the state government, which are presumed to be in line with the directions. So if it's if this portion is sustained also in terms of relevant government order notification, then 2024 should come in.
Yes.
Next page, yes.
The modification should be made in line with the reduced financial solvency limit or other notices across the state where the margin has been half. The zone of consideration, including for self-help, will be in accordance with the latest notification. What is the latest notification? Government order 2024 control order was published pursuant to the division bench judgment of so. But if that is accepted, latest control order, latest notification, then my lord, everything will go.
Our state has issued government orders in terms of the central change in the 2024.
Kindly read, my lord.
Give a copy of that.
Kindly read, my lord.
Oh, this, right.
Kindly first part.
Right. This. Yes.
Kindly read that. First page. This order may be called the West Bengal Public Distribution Control Order.
So even if you don't interfere with this order, retain it, then also it has to be 2024.
Absolutely. Whoever eligible, who will apply? A lordship cannot set back the position. Today it cannot be done. Can you read, my lord?
Yes. Whereas the government of India exercise the power.
Act and 2015 control order, both. Because, my lord, this is a delegated legislation under section 5. State has to proceed on the basis of the direction of the central government. Central government 2013 control order, National Food Security Act, 2015 targeted public distribution control order. Section 5 says you have to frame a rule following section 3 and
2024 does not contain anything for women's self-help groups.
Yes, that has
Special,
yes.
what is that?
That is not kindly turn to 30, clause 30. Eligibility criteria, Roman 3. A3, page 30. 30A3.
Not women, any self-help group.
Self-help. That's
Most of the self-help groups in West Bengal are women run. Yes. Most of the
So for we are concerned about 12 women. But company have been debarred.
But
Company has been debarred.
that is very ominous.
Mr. Dasgupta,
Mr. Shen, this was. So you wanted to cite something?
Yes.
We'll continue after this and take your judgments and
Before that, before the Lordship observe that. We had a meeting, we have a meeting at 1:25.
what happened again?
Probably with Mr.
3:30?
I don't know what will happen, my lord.
Who?
If you Lordship kindly
Those
keep it
two.
tomorrow.
Tomorrow. Those two.
For abandoned person.
Abandoned.
What? Abandoned caution. Mr. Basu, you are on the verge of completion. We'll forget whatever we had.
Predicament.
Yes.
Yes, you are the cause of all this.
Now I am not there, but I cannot.
If you are given free hand, you would push people off the balcony. And...
If he says it will be happen, if he not say, it will be happen.
No,
Everybody knows.
wanted. Why? Who?
I don't know, my lord, for.
You don't know whether that person is there or not.
No, for Mr. Dostur.
For Mr. Dastur,
Pathard, my lord. Pathard.
For him.
No, we won't make it Pathard if it's relegated till.
I shall take another
I
5
have heard, but I will think tonight. If something is to be said, I will come. Otherwise, I will say.
Mr. Basu, we are not recording anything. If it continues after 2 p.m., if court continues after, if you don't, then you come. We are not passing any order right now. If you are not there, ask somebody to mention. Then we'll just record that you have heard it part and keep somewhere or even they will. Yes, they will be pointed. Yeah, fair enough. So,
Only one thing. Yes, my lord. Only one thing. Sorry, my lord is rising. My lord, only thing, my lord. He just made a submission right now. And section 5 is two different thing. That the section 3 invocation is সেটা বলো না তাহলে আমি ওইখানে আর্গুমেন্ট করব
so we'll hear about section 3 after recess. Resolution taken?
From 2 p.m.
Why 3 days? One day on the day of the death, I also went there. 3:30, obviously there will be a full court reference. Why today?
That's why I was also in that meeting. I am wanted to say that when there is a court reference, then why should we do? But everyone poured upon me.
Pounced upon. There will hard in part for further hearing tomorrow.
My lord, day after tomorrow, kind of.
Tomorrow we will take up assigned matters first every Tuesday from now on. So it may not be reached also.
Day after tomorrow.
Let it be in the list tomorrow for further hearing tomorrow. If you have any difficulty, we will grant it. Just inform Mr. Shah in advance.
No, my that's it.
Yes. এটা কালকে লিস্টে থাকবে পাঠাট হিসেবে বা ইয়ে কিন্তু পাঠাটের উপরে থাকবে সাইন অ্যাপ্লিকেশনে ঠিক পরেই বলে দিচ্ছে হ্যাঁ পাঠাটের উপরে থাকবে থ্যাংক ইউ এটা ঢুকবে সরি এটা আমার কপিটা ঢুকবে ভুলভাল ঢুকিও না ঠিকঠাক কপিতে ঢোকা যায় না এটা আমার কপিতে ঢুকবে কিন্তু ডিফেক্টটা কি দেখি From a report of the assistant registrar dated August 28, 2025, we find that the appeal has been erroneously classified as a regular first appeal instead of a first miscellaneous appeal, comma, which should be the proper classification, comma, since the matter arises out of the Guardians and Wards of a proceeding under the Guardians and Wards Act 1980. Full stop. Accordingly, let the necessary rectification in the memorandum of appeal by classifying the appeal as a memorandum of appeal from original order be carried out by the learned advocate on record for the appellant by during the course of the day. During the course of just in the memorandum instead of original decree, score through the decree and write order.
Okay, Lordship.
Original order, but the advocate on record has to do it with the leave of court with signature.
Okay,
both judges' copies. During the course of the day, full stop. The matter may be sent down. The matter be sent down to the department for renumbering, for being renumbered as a first miscellaneous appeal. Full stop. After such renumbering, comma, the matter be sent back to the file be sent back to the court. Full stop. The matter shall next be listed under the heading Order 41 Rule 11. Oh, আমাদের তো নেই আচ্ছা না লাস্ট সেন্টেন্স যেটা বললাম আফটার বিং রিনাম্বার ওটা কেটে দাও তার আগে পর্যন্ত থাকবে since several orders have been passed in connection with the appeal, comma, it is deemed that the appeal has already been admitted under already admitted for hearing. Full stop. Accordingly, comma, after the reclassification, comma, the appeal be listed under the heading application on September 8, 2025. Carry out the correction today. Office will carry out the correction accordingly. Reclassify, give a renumber. We have deemed that the appeal has already been admitted.
Okay, grateful, Your Lordship.
And it will appear under the heading application like today on next Monday.
Lordship, there have been some developments. Shall I submit on that day or?
On that day.
Okay, grateful, Your Lordship.
1980 বললাম না ওখানে 1980 লেগেছিল ভুল 1890 হ্যাঁ হ্যাঁ হ্যাঁ
Item number 11.
My lord, this is my application for
Yes.
excess hearing, my lord. Actually, when on last day, lordship kindly consider my lord's last order, my lord. There's a defect, my lord. The decree was not there, my lord. Accordingly, I've had the
You are ready with the degree?
my lord, my lord.
File it in court.
Yes, to the
So there is no other defect, Mr.
no, no,
Chakravarti?
no, my lord, no, my lord.
No other
So far as
defect.
I peruse, my lord.
Just once check up. Very well. The original certified copy and second judge's copy of the trial court's decree is filed in court today by learned counsel for the appellant and be kept on record. Full stop. Let the same be tagged with the memorandum of appeal. Full stop. The appeal, thus, is deemed to be free of defect. Full stop. Next para. The present application is one for expeditious hearing of the appeal. Full stop. In view of the innocuous nature of the prayer, for prior service of copy of the application on the respondent is dispensed with, full stop. Can 1 of 2025 is allowed, thereby directing the appellant to put in the postal costs and due requisites for service of notice of the appeal on the respondent within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Fine.
No rest to cost.
Item number 12.
Two defects have been pointed out by the office. First, the appeal is delayed by 37 days, but no application for condonation of delay has been filed. Next para. Also, the memorandum of appeal needs to be classified in words. The learned advocate on record appearing for the appellants is directed to carry out the necessary rectification in the memorandum of appeal by September 4, 2025. Full stop. Leave is granted to the appellant to take out an application for condonation of delay and mention the same as and when the same is filed for inclusion in the list. Full stop. Let the matter go out of the list for the present.
Item number 13.
None appears for the parties at the time of call. Let the matter stand adjourned for the day. কেউ না এলে আর ফাইল দিতে হবে না
Item number 14.
Same order. None appears for the party.
15.
Same. Same. An adjournment is sought on behalf of the respondent. Although none appears for the appellants. Full stop. Let the matter stand adjourned for the day.
Twenty.
19.
Your Lordship, I'm appearing on behalf of the appellant.
In 19 or 20?
In 19, item number 19.
You are appearing for the?
Appellant.
Yes.
Your Lordship, kindly fix the next date.
On the prayer of the appellant, the matter is adjourned for the day. Give your name.
Your Lordship, kindly fix on the 8th September.
Why? No. Tomorrow. tomorrow we'll take up assigned matters first. So this may not be reached also. We don't know. Only not today. You give your name. Honestly, only your name, not your senior's name. Yes.
Item number 20.
20 তো হলো না ওটা 19 ছিল না 20 none appears for the parties at the time of call. Let the matter stand adjourned for the day.
Item number 21.
Same.
Item number 22.
Same.
Item number 23, 26.
Same. Give the item number, write the item ওটা নিয়ে নিন
Item number 20.
অর্ডার রেকর্ড করতে হবে না শঙ্খ অর্ডার রেকর্ড করতে হবে না not today. Same. Not today.
30.
Not today. Same.
32.
Same.
33.
Same. করে যান
37. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 48. 49 is 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 61. 62.
ডেকে নিন Yes.
No.
একটা সিএবি হয়েছে না
My lords.